Welcome to the second hearing of the committee's inquiry into the application of the contractor and employment agent provisions in the Payroll Tax Act 2007. Firstly, I acknowledge the Gadigal people of the Eora Nation, the traditional custodians on the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us today. My name is Jeremy Buckingham and I am the chair of the committee. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of the hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Firstly, I welcome Mr. Aquilina and thank you for making the time to give evidence. You have already been sworn before this committee during this inquiry and do not need to be sworn again. Would you like to start by making a short statement or introductory remarks?
I would, Mr. Chair, and I just want to say to you and the committee, thank you very much for the honour of being able to give evidence again in this inquiry. It's a great pleasure to be with you. I think it'd be morally obtuse of me not to recognise the tragic events that happened in Bondi over the weekend. As a jealous Melburnian and a proud Victorian, I must say we're no longer Victorians and Melburnians today. We're New South Wales people with you today in recognition of what is a tragic moment in Australian history. But I hope that that can put into perspective the reality that we have a wonderful democracy, a wonderful country, and the opportunity to be able to come here peacefully today and talk about important issues like payroll tax just emphasises that ultimately peace, love, unity, the immigrant character of our nation will always prevail over what is unquestionably the evil of anti-Semitism. And I want to send my condolences and support to all the people of New South Wales. We're all New South Welshmen today.
Thank you, Mr. Aquilina, and the fine sentiments.
Just in terms of the payroll tax provisions, there is obviously a very big issue with these provisions, that is its reliance on the concept of service as a moderator for determining what is an employment-like relationship. And it is the absolute reliance by Section 32(1) on that concept of services that is creating vast difficulties with how the provisions are being tackled by the courts, how they're being interpreted, and how they're being administered by the revenue. The problem with the concept of services being the basis for determining an employment-like relationship is that it's an incomplete way to describe what an employment-like relationship would look like. And the biggest difficulty with language, and we've seen this with many learned people over time saying that language is an incomplete tool for which we have to interpret the world, let alone through legislation. The problem with the concept of services being the arbiter is that it has to be interpreted by someone as to what its upper limits are. And it seems to me that the upper limits of this concept of services just continues to grow and grow and grow. And it's not just because arrangements today that are being entered into are novel or new, that does influence the analysis, but it's because the nebulous concept of the upper limits of the concept of the word service are creating difficulties in the way in which the courts are approaching the interpretation of the legislation. So you can have arrangements now where the parties never intended to be their service relationship, where a contract never reflected a service-like arrangement, where still, nonetheless, the courts will impute that a service-like relationship exists merely by implying that a reliance on a financial benefit, for example, through the supply chain exists, therefore justifying that a service might exist on that basis. We can explore these issues today, but the case law continues to grapple with this. And the recent decision by the Court of Appeal in New South Wales in Uber has just demonstrated again just how far this concept of service can go. And I think that the Parliament has an opportunity here to really clarify what the characteristics of an employment-like relationship should be. Now, services may be in the mix. In fact, in our submission, services is not a bad way to justify a portion of that analysis, but it has to be grounded in integration and control. If there's no integration and control between the principal and the contractor, even to some extent, even if there is the presence of a very nebulous, broad deeming idea of services, then there is no employment-like relationship. The consequences of this, as I said when I appeared last time, is that the most vulnerable people in the supply chain are suffering the economic issues that are associated with this tax being passed through the supply chain. And it's all hinges on this basis that there is a lack of clarity in the scope and obviously the application of the law. The courts can only deal with cases and controversies. They can only deal with fact-specific matters that come before them, and I've given full credit because it's very difficult to read these provisions. But only Parliament can lead the way in terms of drawing the line, making it clear and giving certainty to business. New South Wales can lead the nation on this. And I think that the fact that the inquiry has met now twice and has done a lot of work indicates that it is willing to. And I'm very excited about the opportunity to work with this bipartisan committee in any way I can to ensure that the law is clarified and to assist not only the New South Wales economy but ultimately the Australian economy at large. Thank you, Mr. Chair.
Thank you, Mr. Aquilina. Well, I'll kick off with one question, and that is, you propose that the core threshold test in section 32(1) should be reformed, moving from a services test to a newly, as you've said, control and integration test. You suggest legislative amendments, so section 321 will only apply if the designated person is substantially controlled by and integrated with the principal. Why is that superior to a test of benefit received?
Well, the problem with benefits received being the arbiter of what is an employment-like relationship is that it doesn't set the limits of what benefits fall within the acceptable parameter of benefits to be employment-like versus something else. There's no doubt that every commercial transaction has a benefit contemplated in that arrangement. Otherwise, no one would enter into contracts in the first place. But what makes something employment-like? Remember, payroll tax is a tax on employment. It's not a tax on transactions. It's not a tax on supply chains. It's a tax on employment relationships or things that mirror or are similar to employment relationships. What makes an employment relationship is something where there is a degree of integration and control between the principal and contractor. I've used the word substantially in the proposed legislation. Parliament might decide to lower that threshold. That is something that could be perfectly amended. I just think substantially gives a bit of robustness to the actual analysis. So it's not really about a superior test in the abstract. It's actually about realigning the law to concepts of employment that have been around for over 150 years, which I know members of this committee have written about before and aware of, without undermining the purpose of these provisions, which is to capture these arrangements where the workforce is being artificially or in a contrived manner outsourced to independent contractor relationships in ways that would undermine the payroll tax base. So there's a balancing act here, and I think that the proposed legislation we've put forward gives you a starting point to rebalance it in the correct direction.
Thank you. The opposition, you have some questions? Mr. Tudor.
Chair, since you made your submission in February, we've had the Uber decision come down. If you were rewriting your submission now in light of the Uber finding, what change would you make to your submission?
I don't think we'd change what we propose in terms of reform, but we'd highlight again in our section on services the nebulous concept of services being extended beyond its natural meaning.
Do you suggest that the Uber decision's wrong?
I don't know if I'm in a position to say that. I mean, the court's made its decision. I don't agree that the concepts of services should be interpreted so broadly.
Well, you're acting for Uber. Do you
I'm
think
not
it's
acting
wrong?
for Uber.
No,
Mr.
no.
Chair.
If you were.
Yeah, well, if I were acting for Uber, then they'd be paying me to say that it's wrong. Yes.
Yeah. And do you think it is wrong intellectually?
Yes, absolutely. Yes, I do. Yeah.
Why?
I think it's wrong because I think that the mere fact that a person derives financial benefit from the related activities of another person in and of itself is not a service. I think that's to take the concept of service beyond its natural meaning and in a way that the employment law at the very least has never contemplated employment-like relationships to be.
So would you agree that if the High Court disagreed with your view, that would give significant clarity to the nature of employment contracts for the purpose of the Payroll Tax Act?
If the High Court overturns the Court of Appeal's decision, it'll provide some clarity.
No. Say it agrees with the Court of Appeal decision.
Well, if it agrees with the Court of Appeal decision, it'll provide some clarity based on those particular facts and circumstances of what might constitute a financial benefit related service in that context. I don't think it provides certainty across the board because, as you know, Mr. Tudor, people will structure their arrangements in all sorts of ways, and there'll be unintended consequences following that decision that we can't even contemplate now. That might apply.
Isn't that the problem with your proposal as well, though?
I wouldn't agree with that, Mr. Tudor. I think compared to what you're starting with, it's a vast improvement.
Depending how you draft your contract, whether an interpretation of control and integration is a factor of the contract is just a drafting issue, isn't it?
Well, it's not necessarily a drafting issue because if you look at the definition of contract in the provisions, it goes beyond what is merely written. In fact, it's now so broad that we can even look at things that parties didn't even contemplate. In fact, you can even look to the vibe of whether or not there is some form of abstract benefit to determine whether it's a service. So I wouldn't say the contracts play a huge role in and of themselves anyway, based on the current approach to interpreting the legislation. I think, Mr. Tudor, hope you and your colleagues can work together to actually realign these provisions in a way that will provide more certainty and clarity to business so they can ensure that their arrangements are clearly reflected and contemplated in either written or conduct in a way that actually reflects employment-like relationships if that's so intended to be captured. I mean, at the moment, it's a nebulous, never-ending pool of uncertainty.
So is your model based on a definition of employment which would require the Parliament to actually specify all those things which are a component of the so-called integration and control model which you are suggesting?
Well, it's not unusual for Parliament to set out indicia.
But
Yes.
you would say a legislative regime which says these are the things that will indicate whether someone is employed or not for the purposes of the Payroll Tax Act.
Just to be clear, what I'm proposing is a number of indicia that are non-determinative. If you read the draft, it says that they're things that the court may take into account to determine whether or not an employment-like relationship exists under Section 32(1).
And that brings in exactly the point that I was making to you, that because they are indicia only on your submission, that it becomes a drafting issue.
Of the contract or the legislation?
Of the contract.
I think it also goes to the conduct of the parties as well, Mr. Tudor.
Well, and that's the common law position, isn't it?
Well, the common law does...
The multifactorial position that the common law adopts in relation to what constitutes employment is in fact exactly the sort of notion that you would be proposing, is it not?
Well, we've borrowed from the common law concept, of course, because this is an extended definition of employment, not an abstract definition of something else that's unrelated.
Well, let me ask you about that. Well, one of the things that you say is for the purposes of imposition of payroll tax, it has got to be for a legitimate purpose. Mm-hmm. Do you recall that's part of your submission?
Yes.
So, given the constitutional restrictions on what states can legitimately tax, do you say that it is illegitimate for a state to tax payments to contractors?
No, I don't say that at all, Mr. Tudor, but I don't think I've ever said that.
Well, for the purposes of this hearing,
Well,
could the amendment effectively provide for an alternative payroll tax provision that it does in fact apply to contractors?
Well, there is a provision that does that. That's Section 32.
Yep, 30.
Yep.
So, but you make a decision about contract for service and a contract of service, and you want to differentiate between those contracts for the purposes of the Payroll Tax Act, do you not?
The law already does that to some degree. What I'm saying is that you should reform these provisions to align it to its intended purpose, and to ensure that it only...
And what do you say the intended purpose is?
To tax arrangements that are employment-like and originally artificially contrived in a manner to avoid the application of the common law definition of employment under the Act.
So it was originally a tax avoidance position?
Yes, it was.
So effectively, the drafting can become a tax avoidance position.
So are you suggesting perhaps that the anti-avoidance provisions would apply? Is it?
Yes.
Well, look, I can talk to that if you'd like about the anti-avoidance provisions. So The problem with the general anti-avoidance provisions, Mr Tudor Hope, is that if you read them, they're equally as unclear as the provisions that we're trying to reform today, and they actually apply on a general basis. And they usually rely on concepts of understanding what the objective purpose of the parties are when entering into transactions. The courts have been, I think the administrators have been reluctant to apply those provisions because they're very complicated to apply to a broad set of arrangements, and I'm not sure they're the adequate answer to the drafting issues that currently exist in Section 32(1), although if we were to reform the law, then I guess the Commissioner could use them as a backstop to prevent any further contrivances from occurring. But the Commissioner's not using it for a reason, because he doesn't need to. The current law is so broad and nebulous, he can apply it to anything.
In your submission, you say this at paragraph 154, an effective system of taxation must be adaptable to new business models and economic trends in order to remain certain and enforceable in response to changes to the modern economy. Mm-hmm. You recall saying that?
I do, yes.
If business models, and this is the question I put to you, are shifting away from direct employment to new models involving various contractor relationships, is there any reason why the state should not tax contractor payments as well as employee payments?
I've never advocated a position where you shouldn't advocate contractor payments. I haven't advocated for the abolition of Section 32(1). I've simply advocated for reforming that provision to ensure that it only captures the class of contractor arrangements that Parliament indicated to the community it would tax when it enacted these provisions, and to provide further certainty to business and the community about what is in and what is out. That is not currently possible under the current state of the law.
So the thrust of your submission is that you would want more clarity about what constitutes an employment contract for the purposes of the Act, is that right?
Yes.
And you would encourage Parliament to amend the Act for the purposes of specifying all those indicia of what an employment contract is?
Yes.
Which is the current multifactorial
Well, it's
common
not
law
the current
approach.
multifactorial test, Mr. Tudor Hope. What it does is it integrate. What it does is, if you looked at a pendulum, the common law test says too far to the left, and we're so far into the nebulous right, we're not even on the planet. The point is, what it's trying to do is anchor it back to notions and concepts that are actually predictable, reliable, and have been the state of the law for over 150 years, that people presumed would be the case when these things were when these things were enacted, have operated on that basis since they were enacted, and now finding themselves in a position where they're perhaps surprised by the fact that it's not being applied that way, and the courts are having great difficulty in interpreting the law to be consistent with that intention. So all I'm trying to do is provide
do you agree with the suggestion that the High Court, in fact, may do exactly what you're asking Parliament to do?
The High Court can't rewrite the law, and I think that's what I'm asking Parliament to do. The High Court can provide...
Well, when you rewrite the law, aren't you wanting more clarity about what the law says rather than rewriting
Well,
it?
I think in order to provide more clarity, you're going to have to update these provisions. I've provided a minimalist approach. You might be able to provide an even more...
Well, the High Court may do that, may it not?
Well, I don't think they're going to tell you how... It's not the job of courts to determine cases in the abstract. They determine cases based on facts, Mr. Tudor Hope. So they'll provide certainty on whether it applies to Uber's arrangements, on Uber's facts. They might provide some broader comments about whether the concept of service has gone too far in their mind. They might, I don't know. If they did, that'd be great, but it won't resolve this underlying issue.
They are being fundamentally asked to, in fact, to describe whether the contract which exists between Uber and its drivers represents an employment contract. In doing that, wouldn't you agree that they will have to turn their mind, or the judges will have to turn their mind to what constitutes employment for the purposes of an employment contract?
Well, they have to turn their mind to what they believe the definition of services is. Yes. Under the current legislation.
Won't that give greater clarity?
It could. I don't think it necessarily will resolve the uncertainty that is the preemptiveness for this inquiry. I don't think it does the job. I don't think courts are placed to legislate, Mr. Tudor Hope. I don't think it's their role. And I think that although it might be a helpful decision, it might be a very unhelpful decision too. We've got to be careful anticipating what the High Court may or may not do. I don't think it resolves the issue. I think it needs parliamentary reform.
Mr. Aquilino, I will just turn to some questions from the government. Dr. Kane.
Yes, just following on from the line of questioning from Mr. Tudor Hope and your answers to them. So you're contending that at the moment there's a breadth to the provisions and the interpretation, but you're also mentioning that there's been a change in business models, which I've taken an interest in over time. Isn't it isn't there some argument to say that actually having a breadth in provisions is actually a flexibility that allows new business models to be captured, given that you've also seemed to have conceded that some of those new business models are used by less scrupulous organisations to circumvent not only payroll tax, but I'd contend labour law. So isn't there a benefit to having, in some cases, to having a broad scope to provisions?
I agree in principle, Dr. Kane, but there's a broader principle at play here, and that is the rule of law. When Parliament passes a piece of legislation with a particular intended purpose and scope, it isn't appropriate, I think, for the detrimental reliance interests of the community, for it then to permit that legislation to be applied in a way that falls wholly outside its intended scope and purpose.
Can I just stop you there, because that's your interpretation, is that it falls wholly outside. We've had an appeals decision say that it, interpreted in a different way. So it's a little bit in the eye of the beholder, isn't it? And it'll be the same with the High Court decision, whether one agrees that it is helpful or unhelpful. A lot of this surely really relies on your position as a business or the representative of business, and whether you think it's beneficial to their chosen business model. I mean, isn't that the case with most legislation?
Well, I would first say, in regards to your first comment about the Court of Appeal, I don't think they've agreed with they've made no comments on the policy of this. They've looked at the word service in the legislation, and they've made a determination of what they think that means in the context of the specific facts that turn before them. I don't think the courts would ever make a view on the policy and whether or not the policy's gone or the legislation's permitted interpretations beyond the policy. I'm here to talk about the policy, and I think that the policy does not align with what was intended, and I think that the detrimental reliance issues that are arising as a consequence of these overly broad interpretations is a big issue, and I think it's something that could be easily fixed without prejudicing the revenue, and could ensure that the New South Wales economy, and hopefully the rest of the Australian economy, cannot be in a position to prejudice and hurt the most vulnerable, because this is who are being hurt by these provisions, I have to say. It's not the big end of town.
Well, just on that, give me an example of
Yes,
that. How do you
please.
say the most vulnerable are being?
Well,
My question.
Every single contractor that is impacted largely by these decisions are sole trader contractors who themselves are starting their own small businesses, who are operating those businesses in good faith under the idea that it is their businesses, and the costs, although not imposed on them directly, imposed on, say, an intermediary, are being directly imposed on them. That is hurting them, and these are people who operate on low margins, who are operating in circumstances where they have very little control or imbalance in these relationships. And I think that the unfair impost of this tax is that it is inevitably going to hurt those people, and it is hurting those people, whether it be the single operator mortgage broker or the driver or the cleaner or the telehealth provider or whoever it may be. These people are bearing the cost, and that is an obscurity of the system. I don't think Parliament ever intended for that to happen, and I think that it's something we've got an opportunity to correct it.
Can I just follow up on that? The characteristics of the people that you describe as being vulnerable are exactly the types of characteristics that you would expect in sham contracting. Mm-hmm. These are the people. So sham contracting is often set up to avoid exactly the things that we've been talking about, i.e. payroll tax and labour conditions.
Yeah.
So isn't it that really this is just another example where the intermediaries are actually exploiting the people down the chain, rather than a failing of payroll tax provisions to capture the right people?
There's always truth between these things. I'm sure some intermediaries exploit their contractors. Yeah, I'm sure that happens. I can't deny that. Also, the provisions enable them to enable this tax to be passed on in a way that is unfair and captures relationships that would never have been the subject of this conversation perhaps 10 years ago. So I think it's a mix of multiple things that are going on here. The point is, society has changed, the economy has changed, these relationships need scrutiny, and they are being subject to scrutiny. But my point last time and my point this time is that what Parliament can do is provide certainty about what the upper limits are to ensure that the provisions are aligned to intended purpose as a question of certainty. If Parliament wants to expand the provisions or introduce a new tax, it is within its rights to do so, Mr. Tudor. For example, the question you asked earlier, it's within its rights to do so constitutionally.
No, I'm not saying introduce a new tax.
I'm not saying you are, but saying constitutionally, you're asking within its scope. Of course, it's
But be very careful, I'm not saying it.
within its
Order.
We got it.
We got it.
It's within its
Hands
rights.
down.
It's within its rights. The point is that what we're arguing is that these provisions need to be aligned to its intended purpose and needs to capture those relationships that have an employment-like nature to them.
And I guess that's my point, though, is that the relationships you're describing as being most vulnerable are very, very, very employment-like.
Well-
So you were talking about control. You were talking about, aspects. I mean, you're talking about cleaners. I mean, you chose examples that are notorious for having employee-like relationships concealed through contracting provisions. So,
Yes.
it's an interesting example you gave.
Oh, well, I mean, it's sure. I mean, that's right. I agree. But the question really is, what are these provisions designed to do? Right?
Will capture those relationships.
Well,
is
they're
what
designed to
do.
capture. Yes. But just because they happen to capture some arrangements that say one person might say are favourable doesn't mean that the policy is right. You can cast a broad. I mean, my colleague said last time everything's in unless it's out. I don't take that view. I think language has got an upper limit. The problem is if everything's in, you capture the good, and you capture the bad. I mean, Parliament. There's nothing stopping Parliament drawing the line, even under the proposal I've adopted. Some of these arrangements might be caught anyway. Because if, for example, there's an arrangement where the cleaner is being directed and controlled by the principal, and there's a degree of integration between the cleaner and the principal's business, and there's a service, well, you're in. So I don't think we're speaking across purposes here. All I'm saying is that there needs to be a degree of clarity around what the upper limits of this is. The courts aren't in a position to do this in a way that's satisfactory, I think. Because they can only determine individual cases and controversies. What Parliament can do is provide minimalist change, I think, and clarity to get the right outcome, to make sure the line is drawn and make sure there's certainty going forward. And I think that's a really good thing for the economy.
Mr. Nanva, you put your hand up.
Thank you, Chair. Look, if I can just follow on that point, the policy intention of the Act was ostensibly as an anti-avoidance measure. On that we all agree. You've suggested that should be grounded in integration and control, which for me is a very early 19th century view of the economy and working relationships. Why is that notion of integration and control more relevant in determining an employment relationship in 2025 than factors like the risk and job insecurity of the labour involved, or the degree of economic and bargaining power? Because in many of these relationships, these people can't set their own rates. They've got no bargaining power. Why are those factors less relevant than integration and control, which harks back to the master-servant era that's just no longer relevant today?
Just to be clear, the test we're proposing is integration, control and service. Okay, just to be clear. All right, but just in terms of the emphasis on integration and control, I mean, these are the things that the federal government have recently reintroduced in the Fair Work Act as factors that need to be considered in light of the fact that the High Court said, well, you just look at the contract and the word in the contract and that's it. So I'd say, yes, they might be grounded in history, but the good thing about things being grounded in history is that there's a relevant consistency and predictability about those concepts, which is one of the issues here. There is no predictability and consistency with how the current tests are being formulated. Now, the factors that you've highlighted around risk, control, around bargaining power and contracting, I don't see for any reason why they don't fit into those existing notions. I mean, the idea of integration and control, particularly under the master and servant relationship concept, was a question of imbalance. It was a question of assessing imbalance and then determining whether the degree of that imbalance meant that the principal controlled or was able to direct and control a purported employer or agent in a way that is employment-like. So all we're trying to do is put meat on the bone of what is an employment-like relationship, and we can't ignore 150 years of history. Now, if Parliament wants to add additional factors that might be relevant to that exercise, then that's something that we need to consider. I don't see how anything you've said might not be arguments that would be made by a competent person to the revenue or against the revenue based on the existing criteria we've set out. But like I said in my paper, I think there's some humility in there. I said that I'm not a parliamentary draftsperson, but it's there for your consideration, and I think that it's a better realignment than what we're currently dealing with, which is nebulous uncertainty.
Chair.
Mr. Rath.
Thank you. I just wanted to move to Revenue New South Wales. I don't know if you remember their evidence from what seems like an eternity ago now to this committee. But, and I take the point entirely in your submission about how the economy has completely changed from when payroll tax was first envisaged. But isn't it also the case that Revenue New South Wales' interpretation of how they apply payroll tax has also changed?
I've got to be careful, Mr. Raff, because the commissioner he's representing said nice things about me when he gave evidence, so probably a first time in history. But yeah, no, I agree with that. I think that and like I said, I think I said to Dr. Kane last time, for all sorts of political and economic reasons and all sorts of practical factors, the revenue has been needed to interpret these provisions, being confronted with revenue demands, but also being confronted with new arrangements that have never been tested before, and legislation gives them the opportunity to interpret these things as broad as they can argue. So yes, I agree. I think if you would ask people in the mortgage broking industry or people in the medical profession or other professions whether or not the law has changed in terms of its administration, I think they'd unequivocally say to you yes, and I would agree with them.
And you think it's potentially part of a tax grab?
Well, I mean, tax grab's a political term, Mr. Rapp. There are revenue constraints, and the revenue they're a revenue collector. The Commissioner of Taxation collects revenue, and he has targets around the collection of revenue. And I have to say he's been well within his rights to pursue because he's won. Okay, yeah. So he's upping. There is an upping in the rate of collection of revenue on these arrangements because they were never taxed before. So yes, clearly there has been a change in the way in which this had been administrative and enforced by the Commissioner. Definitely.
They argue, if I can recall their evidence, that it's a matter of enforcement, that they haven't changed any interpretation. They haven't, basically nothing's changed at their end, that it's essentially just that they're now enforcing what has always been the case, which is very different to almost every other stakeholder that we've heard from, which have said they've been hit with retrospective payroll tax bills that they never thought they would have to pay.
I don't agree that it's a change in enforcement, because that would imply unfairly to the Commissioner that he has decided not to enforce the law.
For decades.
For decades.
Yeah.
I don't think that's fair. I don't think that's what I don't think any Commissioner of Taxation has ever approached the administration of that role in that way. I think what has happened is there's been changes in the economy that have invited opportunities to test what are very broad limits of wording in legislation. We're lawyers. We do this for a living. Clients come to us. We look at these things to try and exploit the broadness or the narrowness of provisions. That's the lawyer's game. My view is that might be the lawyer's game, and we might make money doing that, but that's not very good public policy. And I think the Parliament now can draw the line and say, okay, well, we accept that this is where the law's gone. Here's where the line can be on these issues. There's always going to be room for interpretation because semantic language has its limits, right? But clearly, just to go directly back to your question, clearly the Commissioner has taken a broader view of services and has pursued that successfully in the courts, and that's why we're here, I suppose. It's created this controversy and mismatch between community expectations around what the law is versus how it's applying to them today.
Thank you.
Well, what do you say those community expectations of what the law is?
Well, I think the community expectations were that these wouldn't apply to bona fide independent contractor relationships.
Well, and that's the question.
That's the crux of it.
That's the crux of it. Is what all these cases are now seeking to test is what is a bona fide independent contractor.
I think the cases make clear that they do apply to bona fide independent contractor relationships despite their purpose. I think Justice Richmond said that in Loan Market.
Loan Market, what? We'll talk about Loan Market. I think Loan Market, the court said that the provision might be harsh, but it's the law.
Well, it is the law, and I think that the court has to grapple with the fact that the language is so broad that it's capable of applying in ways that perhaps it haven't applied before. I don't think there's anything consistent in Loan Market with that principle. I think he makes the remark that it can apply to bona fide independent contractor relationships, and that is a harsh result. That's what he says, yes.
Mr. Nanva.
And the policy purpose...
Excuse me. Mr. Nanva.
Thanks, Chair. Probably just, look, one more question from me. I'm very sympathetic to your call for certainty. And, you know, if Parliament needs to push through some new laws to provide that certainty to business, then that's always a good thing. But the difficulty I've got is that legislation can be a very blunt instrument at trying to anticipate every unpredictability in life. Particularly in a modern economy with the sort of modern technology that we're seeing. Ultimately, the problems you speak to are just a challenge as old as time, aren't they? That you've got businesses using modern tools, modern technology, different business structures, ultimately with a view to minimising their tax, which is an entirely legitimate thing to do. But the issue since the 1980s, when you know these laws were ostensibly conceived, is that the sophistication of the technology and the legal advice around that has just got to a point that we couldn't have conceived 30, 40 years ago. Like, this is just the challenge as old as time, isn't it? You can't have laws that can predict every scenario in life.
Yeah, no, I don't think I've ever contended that's what the law can do, and I agree with you. That's always a limitation of language, let alone the law. I mean, there's always going to be interpretive limitations to it, and the law can be a blunt instrument. What I'm proposing is that you adjust the law, and I'd say a minimalist way, to align it to what its original objective is, unless there's a policy decision to expand it beyond that. I think I want to just challenge very briefly. I don't think that there's a lot of these businesses are engaging in these arrangements to minimise their tax. I don't think that's a fair thing. I think tax is always a consideration, but I have to say, as an advisor, tax is usually like the last thing they tend to think of. I wish they thought about these things up front. I think there are legitimate arrangements here that have been a product of a changing economy where the tax has been, I don't think, the driving force behind its structure. In fact, if tax had been, a lot of these arrangements might have been set up in different ways to artificially avoid the tax, let alone allow themselves to fall into the trap of falling into this idea of services. They would have managed that better, for example. So I'm not sure about that, but what I will say is that yes, the law is a blunt instrument. Yes, you're always going to have interpretive difficulties. Yes, you can't anticipate every issue, but you can set clear policy parameters about what you think the upper limits of something is or what the lower limits of something is. And I think that the Parliament should do that on this occasion. I mean, these are...
But won't those just be subject to legal advice, legal opinions, challenges?
There won't be a law in history that you write, as smart as you all are, that will never ever be subject to interpretation. What I'm saying is the current state of the law is so open to interpretation and uncertainty that it's causing harm. You can minimise that harm. You can't eliminate the harm, but you can minimise that harm and actually align it better with policy objectives that are accepted as the basis of these provisions in the first place, and ensure that uncertainty is targeted in the best way possible towards the outcomes that I guess the community would expect, and that is the types of administration that's been happening over the last 30-odd years that has changed. I think it's that surprise element that needs to be realigned. Now, Parliament might decide that it doesn't want to do that because it wants to see these provisions expand in a way that has never been applied before, but that's a policy decision. I'm just inviting Parliament to realign it.
Before I hand you... Oh, sorry, Mr. Nanva, please.
Sorry, one more from me, Chair. But you wouldn't agree that this anti-avoidance provision that Parliament at the time, in casting the net of relevant contracts so widely, was anticipating or flagging that we cannot predict the future. So we've defined this as broadly as we have to perhaps capture arrangements that we can't even conceive today?
Look, absolutely. I think the issue isn't so much whether Parliament want to allow adaptability in capturing arrangements. The question is whether or not they ever anticipated that the law would be interpreted so broadly as to apply in a way where, say, parties who are parties to a contract never intended for a service to arise are deemed to have a service through some abstract notion of supply chain benefit. These are the sorts of things that might not have been anticipated, but I think if you put those things to the people that wrote these laws, they would have said, no, it was never intended to go that far. I mean, that's the point. And that has to be true, because look at community expectations. Why are all these stakeholder groups coming to Parliament and saying, we are surprised by this? we don't. Well, it's not just simply. Can I respond to what you said?
Certainly.
I don't think it's just simply they don't want to pay tax, Dr. Kane.
They never paid it before.
They've never paid this tax before. But more importantly, not just that they've never paid it before, there's never been an expectation that they'd pay it. And it's that detrimental reliance issue that's really important. And I, like I said last time, I have full sympathy for the idea that there's a lot of from that can be done around this from a workplace perspective to protect individual worker rights. And I think that needs to be looked at. But this is not the avenue.
Before I go to Dr. Coate, do you think that the definitions of sole traders are fit for purpose in this context? Because I think the common understanding of a sole trader is that they have full control over the business decisions. But in the context of these relationships, they don't. Therefore, are they sole traders? Are those provisions fit for purpose when it comes to these new types of arrangements?
I think I need to admit the upper limits of my knowledge. I haven't looked at the interaction between the sole trader definition and these provisions, but nonetheless to say, the concept of a service is so broad. One of the recent cases before the Supreme Court, which is reserved, the question was asked, if I impose an obligation under a contract to ask you to comply with the law, something you have to do anyway, is that capable of being a service under these provisions? And the Revenue said, of course it can be. So we're not even talking about things that people can't control. Things that people are required to do, if reflected in the contract, could still be a service and therefore a relevant contract. I mean, this is the sort of upper limits that Parliament can provide certainty on. Are these the types of arrangements where we say they're employment-like? Really?
Dr. Kane?
I had a couple of questions which are a little bit sort of going back to previous answers.
Yep.
And it goes a bit to what Mr. Nanda was asking as well. So these arrangements have been around for 30 odd years. Is that correct?
The legislative arrangements.
And, you know, the exchange is, well, some organisations haven't been subject to tax before, and we also had a discussion around community expectations, and they change as well. And you said something which was interesting, which is this abstract notion of supply chain benefit, which I'm struggling to see how it's abstract when supply chain relationships clearly, you can see where the benefit flows in supply chains. It's not a tricky concept. But that is something that has developed over 30 years. We weren't talking about supply chains in the 1980s and even in the 1990s in the way that we do now. So again, and I mention it, and Mr. Nanda has mentioned it, isn't this actually just demonstrating that it's actually might be a benefit of law to be flexible enough to capture changing business structures, and supply chain has become a much more prevalent concept, but also community expectations, in which where you have extremely large, very successful companies at the tops of supply chains, there is a community expectation that there is some community contribution, i.e. these organisations need to contribute to the states in which they operate. So isn't that a positive of this legislation?
The difficulty it's a good question, Dr. Kane, but the difficulty is it's loaded with policy preference and presuppositions around what is desirable. All I can speak to is the fact that we know what Parliament intended when they enacted the provisions. We know how they've been administered. We know where they're going. And we don't know how far they're going to go. And the value judgment that you raise very legitimately, which is relevant for politicians and legislators, is, well, do we care that it's gone beyond its scope? And do we care that it's capturing arrangements of never intended? Do we care that it's having these adverse consequences in the way that it is because we believe it's good policy, because we think the result is desirable?
Well, then it's not an adverse consequence.
Well, sorry,
Thank you.
no, well, I mean, that's a value judgment.
Well, the use of the word adverse consequence was a value judgment.
Well, sure. I'll concede that well, there are adverse economic consequences to these people. There are adverse. A tax is an adverse consequence. It's a cost in the supply chain. I think we can agree with that. That's basic economics. But
paying tax might be a beneficial consequence.
beneficial to who is the question?
Well, society at large.
Well, the point I'm making, I was trying to answer Dr. Kane's question, because she was putting to me the very sensible question, which is, do we care about all these things happening? I can't answer whether you care or not.
I care.
You care. I'm not saying you don't care.
I'm being facetious.
I'm just saying to you that, in my view, as a question of the rule of law and as a question of certainty, if a law is going to go beyond its remit, and even for interpretive ways, there should be an upfront approach to the public where the Parliament passes or makes clear what it wants. There can be a stale mandate in these things. I mean, these things were passed in the 70s, right? Or originally in some form in the 70s. So I'm just saying that Parliament can realign it to what it was and set clear boundaries, whilst also naming to be flexible and adaptable to capture all sorts of arrangements. I'm not saying you exclude these arrangements. I'm saying provide more meat on the bone. Services is not on its own an appropriate mechanism, in my view. Or it can enact new provisions, as I said earlier, that would say, okay, we're going to expand the concept of employment-like relationships beyond what it's been traditionally understood and impose tax on relationships that have never been in tax before, but, as you say, there's community benefit, whatever the policy justification is.
Thank you, Mr. Aquilina. I hate to interrupt you. You've provided a lot of meat on the bone for this hearing. We very much appreciate it. But the time for your evidence has concluded. Thank you for appearing again today before the inquiry and at this hearing. We appreciate your evidence on behalf of Denton's. If there's any supplementary questions, the Secretariat will be in contact in due course to provide those. But again, thank you very much for your submission, your evidence here today.
Thank you, Mr. Chair.
Thank you, Mr. Ackerman.
Thank you very much, Ms. Brunner and Mr. Lachlan, for appearing. Before we commence, if I could get you to state your name, position, title, and swear either the oath or affirmation, and I'll start with you, Ms. Brunner.
My name is Pia Brunner. I am the Director of Public Policy and Government Relations for Uber ANZ. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Super, thank you. Mr. Lachlan.
Thank you. I'm Cameron Lachlan, Legal Director for Uber Australia New Zealand. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Do you have some introductory remarks you'd like to make?
We do. Thank you, Chair, and thank you to members of the committee for the opportunity to appear today. Before we begin, I'd like to acknowledge the tragic events in Bondi on Sunday. Our thoughts are with all those directly and indirectly affected, and we extend our sincere sympathies to the families, victims, and the broader community. We also acknowledge the New South Wales Government and emergency services for their response to this event. We appreciate the careful work the committee is doing to examine how the contractor and employment agent provisions of the payroll tax are being applied across New South Wales. Uber welcomes this inquiry. Across many industries, including healthcare, financial services, cleaning, direct selling, and the gig economy, businesses including Uber have expressed deep concern about how payroll tax provisions are being interpreted. The legislation was written for a very different era, and it is struggling to keep pace with modern business models. Because of that, many businesses are facing uncertainty and, in some cases, serious financial consequences. Our submission sets out 4 main points. First, that the payroll tax contractor provisions are now being applied in a way that goes well beyond the original purpose. These rules were introduced decades ago to prevent tax avoidance in situations where a worker was, in substance, an employee but being treated as a contractor. They were never designed with digital platforms or many of today's modern work models in mind. In Uber's case, drivers are not engaged as employees or as contractors. The Uber platform provides technology and market services that help independent drivers connect with riders. Drivers using the Uber platform choose when and where they work, how long they work for, and many use multiple platforms simultaneously. In other policy areas, for example, industrial relations, we see rideshare drivers recognised as independent contractors. In fact, this Parliament passed legislation earlier this year to bring gig workers, including rideshare drivers, within the contractor provisions of Chapter 6 of the Industrial Relations Act. Yet we see independent drivers being treated as though they are employees of Uber for the purposes of payroll tax, representing a significant expansion of the regime and contrary to the original policy intent. We submit both the relevant contract provisions and the related exemptions are not fit for purpose for modern forms of work. Second, there is a further challenge when it comes to the contractor exemptions, as the onus is on business to establish that the exemption can be applied, even if the data required to prove the exemption is not available to the business. To illustrate this with a specific example, Uber has previously engaged with Revenue New South Wales on the application of the services to the public exemption in the current legislation. Revenue New South Wales has indicated their view that the public is not passengers, but other rideshare platforms. Therefore, in order for Uber to prove that the services to the public exemption applies, it is necessary for us to show that the driver multi-apps and then what proportion of the driver's income comes from work sourced on the Uber platform compared to other platforms. It's really common for rideshare drivers to source work through other avenues, including multi-apping. However, it will not surprise the committee that Uber does not hold data about what income drivers obtain from other sources or platforms, nor would it be appropriate for us to request this information from drivers. This type of data is only held by the ATO. Revenue authorities are able to request this under information sharing agreements, but it is therefore impossible for Uber to provide, at an individual driver level, the earnings data required to meet the criteria Revenue New South Wales has set for this exemption. Thirdly, the interpretation and application of payroll tax is producing inconsistent outcomes and clear competitive imbalances. In the point-to-point transport industry, a booked trip in a taxi and a booked trip in rideshare are very similar from a passenger perspective. Taxi companies and rideshare platforms are each regulated as booking service providers that facilitate bookings between drivers and passengers. Yet because of how the exemptions are being interpreted, taxi companies are treated differently to rideshare platforms. It doesn't pass the common sense test that two businesses operating functionally identical models can end up with very different payroll tax outcomes. It's confusing for business and it creates a competitive disadvantage. Finally, the administrative guidance that business relies on is not suited to contemporary ways of working. For example, guidance on the services to the public exemption and the 90-day exemption was written for traditional contractor arrangements that do not reflect our business models. As a result of issues with guidance and the approach taken by Revenue New South Wales, businesses that genuinely want to engage with the payroll tax framework are left uncertain about how the rules and exemptions apply and are constrained in their ability to obtain clarity. Uber is committed to working constructively with Revenue New South Wales and the government and with industry to improve clarity and consistency in the interpretation and supporting compliance. We support regulation that is modern, fair, and understandable. Our recommendations to the committee are straightforward. We believe the exemptions should be updated so they apply fairly and consistency across industries, with the goal of restoring clarity and aligning the system with the original intent of payroll tax. Finally, I note that Uber has been granted special leave to appeal this matter to the High Court. That process will take its course, but the concerns raised in this inquiry show that the issues here go well beyond any single company or any single case. Businesses need clarity, predictability, and a system that reflects the way people actually work day to day. Thank you again for the opportunity to contribute to this inquiry, and my colleague and I are happy to take your questions.
Thank you, Ms. Bronner. The opposition, Mr. Tudor.
Thank you. And I'll just start by asking this. In terms of the advice you've received, when do you expect the hearing to come on before the High Court?
Approximately middle of next year.
Next year, so that's 26. So in June 26, July 26?
Approximately, we don't have a date at this point.
for the purposes of the position you're putting to the High Court, what effectively do you say, or where do you say that the Court of Appeal is wrong and which should be overturned by the High Court?
Yeah, because the matter's before the court, we're not able to discuss it today.
Why?
That's our position. Sorry, sir.
Oh, so
Well, can't you say why you think that the Court of Appeal has got it wrong?
Well, we think that our business is not captured by payroll tax, the Payroll Tax Act. We think that we operate a marketplace and that the relevant contract provisions of the Act shouldn't be applied.
Well, so the Court of Appeal has disagreed with that position.
Correct.
So what specific aspects of the Court of Appeal's decision do you say the court has got it wrong?
I'm sorry, I'm not in a position to discuss that because the matter's before the court.
Well, I find that a most peculiar position for a lawyer to put, that a lawyer doesn't want to articulate a decision which it has been in a case where it is party. Did you think that the court in the first instance before the single judge got it right?
Yes.
Okay, well, we're making progress.
What did you think we might ask you today? Did you not think that you would come and we would ask you about the appeal?
Yeah, I'm sorry. The advice I've received is that I can't talk about the case before it's before the courts. But, you know, I think there's a few things that we did want to talk about, including the fact that...
It's more a question of what we want to talk about, Mr. Lupton, with
Yeah,
respect.
of course.
Well, okay,
I appreciate that.
Well, I just want to ask this then. What do you say are the characteristics of your business model which take it outside of an employment contract for the purposes of the Payroll Tax Act?
Well, first, we don't believe that there's a relevant contract under the Payroll Tax Act, and that's the case that we have before the High Court.
That's the arrangement between you and the driver.
Correct.
Is not a contract for the purposes of the Payroll Tax Act.
Correct.
Yep.
And that's the case that we have before the High Court. And then separate to that, we obviously operate in an industry where exemptions have been applied for many years, whether that's for the taxi industry or in respect of our delivery business, the carriage of goods exemption.
Well, Ms. Bronner made the point that it would create an inequity between the taxi industry and Uber if this result was to be applied to your industry and not to the taxi industry. Do you want to expand on that?
We don't have direct evidence of what Revenue New South Wales has discussed with the taxi industry, as you'd expect, but there is publicly available guidance on the Revenue New South Wales website which talks about how they see payroll tax obligations applying in point to point. And to kind of paraphrase that, it states that in Revenue New South Wales' interpretation, the services to the public exemption very clearly applies to rank and hail, work that a taxi might do. And then it appears effectively that then that exemption is extrapolated across to any booked work that taxi driver might do. So the exemption appears to apply to both rank and hail and booked trips. And I guess our point is, I almost park the rank and hail. I can understand, or we can understand how that is very much clearly considered services to the public. What we cannot understand is how taxi receives that exemption for booked trips, which are fundamentally regulated and undertaken in the same way as our rideshare business. So in the event that we are unsuccessful in the court, for booked trips, taxi will have an exemption and Uber will not.
If I can just add to that, our assumption is that when the exemptions were implemented, it was never intended that taxis would be captured by the Act because it's an industry that's traditionally bona fide contractor relationships. Similar to carriage of goods for conveyance, they've got a specific exemption that covers their business. It's an industry that, you know, uses large independent contractor workforces, and those exemptions should apply to our business too.
You might even use an app to book a taxi on
Correct.
your phone.
Correct. In fact, if you drive past a taxi like we did this morning, printed along the side of all of those taxis is advertisements for the very apps that they're promoting their riders to use.
Yeah. I mean,
Just a matter of process here, just in regards to the question that was put by Mr. Tudorhope regarding the decision of the Court of Appeal and your indication you did not want to answer that. You do have the option to take that on notice, that question on notice,
Yep.
if you would like, to provide a response later. Or, alternatively, today we could go in camera to hear your response if you wanted to provide a response that is not in a public forum.
We'll take the question on notice if that's okay.
Can I ask this? What would be the impact on your business if, in fact, you lose in the High Court?
Retrospectively or on a go-forward basis?
Well, I think the original assessment was $800 million, was it?
There's two parts to it, I suppose. The first part is that on a go-forward basis, we would obviously have to assess whether or not those costs should be passed through to users. But in a world where the tax is not being applied to our competitors, that's obviously a very unfortunate decision for a business to be put in. Retrospectively, the number is large. I don't have the exact number in front of me, but the assessment period stretches back to 2015. So, like many businesses grappling with the sort of new interpretation of these laws, there is quite a sizable retrospective liability.
Can I just ask you about the process by which this assessment period... Had you ever been the subject of an audit or assessment process before where... and you'd been given an indication about the model which you have used was or was not liable to payroll tax?
My understanding is that an audit was commenced in 2019, and prior to that date there hadn't been any interaction or audits. We launched in 2012, so there was a period of around 7 years where we were operating the business without an audit.
Yeah, but operating without other regulations as well. So.
Sorry?
No, my apologies.
So the first you became aware of your potential liability for payroll tax was following the 2019 audit.
Correct.
And that had followed optical stores.
Superstore case.
Yeah, superstores. Thank you. Did that follow that case?
It was around the same time. I can't remember the exact sequencing of events.
So it was a decision taken by Revenue that it had an expanded notion of what contracts were in fact caught for the purposes of Payroll Tax Act. Payroll tax.
It appears that way, yes.
Did you, in terms of the assessment that you received, did you also receive interest and penalties?
Yes.
As a component of that assessment?
Yes.
Did you lodge an objection in relation to the interest and penalties which were applied?
Did we lodge an objection? Yes.
What was the attitude of Revenue New South Wales to the issue of interest and penalties?
I think I'll have to take that question on notice.
But there was no discussions. Well,
Yeah.
perhaps you'll.
There have been penalties levied. So.
One of the things that you have also, or Ms. Brunner, highlighted and which you've also alluded to, is the fact that there are other opportunities for apps or this new industry model who contract by way of apps. Is it your submission that where there is an opportunity for a new arrangement in relation to contracting, be it digital in its nature, then those contracts should not be caught?
I'm not sure I fully understand the question. Can I ask you to rephrase?
Perhaps it really flows from the previous question. Perhaps I go nothing. If in fact you are found liable for payroll tax, do you concede that you may also be liable for workers' compensation?
No, I don't believe so.
Why? Your employees?
Well, I don't think there's any suggestion in the payroll tax litigation that the drivers are employees or even deemed workers, which I believe is the test under workers' compensation law. It turns on whether there's a relevant contract.
Well, if the relationship between Uber and its drivers is one of an employment contract for the purposes of the Payroll Tax Act, why wouldn't it also be the case that you may also be liable for workers' compensation?
Can we jump in?
Yeah.
I think this goes to the point we were trying to raise earlier. We've been through a long process, obviously, of federal industrial relations reform under the Closing Loopholes Bill, which, although the terminology uses employee like workers, I think really brought clarity that, at least in terms of the federal industrial relations framework, that gig workers like rideshare drivers and food delivery workers are independent contractors. Granted, perhaps a different kind to what we might have seen, when these laws were drafted. But I think we sort of take the view that, at least federally, it's quite clear now that we are dealing with a class of contractors.
That's the previous question that I was asking.
I pointed out, that this Parliament passed legislation earlier this year that says, for the purposes of the New South Wales Industrial Relations Act, we recognise rideshare drivers are contractors. Like, that language was used specifically in the minister's media statements.
Yep.
So there is a contradiction that and I understand that payroll tax and IR are different, but I guess our point is we have viewed that our drivers and rideshare drivers and delivery people are contractors. We feel like that has been clarified in the industrial relations framework, but it feels like the payroll tax jurisdiction is pushing another way.
Yep.
Potentially there is a risk for workers' compensation, although again I note the New South Wales government has an intention to do something in the workers' compensation space for gig workers at some point this year.
Has Revenue given any explanation as to why they want you to collect data on your drivers about how much of their income comes from Uber, as opposed to them chasing up the ATO and getting that information themselves that they're entitled to do? Why have they given any explanation why it should be up to you to?
Well, under the law, the onus is on the taxpayer to prove the exemption. So the Payroll Tax Authority has issued guidance that taxis can rely on the services to the public exemption. We're not sure why, but it would be incumbent on us to have to prove the point, and to prove that our drivers are providing services to the public, we would need to have access to that information from our competitors, which we don't have.
Isn't it unreasonable for individual drivers to be lodging their tax returns with you so that you can determine what proportion of their income is coming from Uber?
It's difficult for taxpayers to have to rely on the exemptions, yes.
One of the things that we talked about earlier was this competitive neutrality. You say that would you accept the regulation of the Uber rideshare arrangement the same way as the taxi industry?
Yes, we're covered by the same laws, same regulations,
Well,
point to point.
isn't there the regulatory obligations which taxis have to be applied to, including licensing, asset ownership obligations and those sort of things, which apply in the taxi industry but don't apply in your industry?
The point-to-point sector is not so much regulated in terms of rideshare and taxi, but in terms of rank and hail and booked trips or booked service providers. So to the extent that a taxi is doing a booked trip and under the premise of a booked service provider, they have the same obligations as we do.
Yeah, and in relation to the ride and hail arrangement, as you call it?
Yeah. Look, I think the distinction that's drawn there is that rank and hail is largely anonymous. So you have a passenger getting into a car with a driver who that they don't know. There's no identification. There is no tracking. So that is my understanding of the kind of the core distinction between why rank and hail and booked trips are regulated differently.
Dr. Kane?
Can I ask a couple of questions, and then I know my colleague has some as well. How much tax does Uber pay in New South Wales aside from payroll tax?
We paid $7.2 million in payroll tax in New South Wales in the last fiscal year in respect of the employees who we have in the state.
Okay, but aside from payroll tax? It's a little bit of a trick question. Aside from payroll tax?
I don't know the answer to that question.
Well, I mean, we comply with our tax obligations. We can take it on notice to provide a more fulsome answer.
Yeah, there is, of course, the point-to-point levy that we also pay in New South Wales, and I'm happy to take on notice the exact amount that we pay in respect of that.
Okay. Am I right? I might have the figure a little wrong, but I think I'm in the ballpark that Uber globally made a profit of about 9.86 billion in 2024.
I would have to take that on notice to check the exact number.
Okay, would that be in the ballpark?
I expect so.
But, yeah, give or take, sure. So you paid 7.2 million in payroll tax last year, was it? In
Yes,
payroll tax?
20, yes.
Okay. And your contention earlier in your answers was that if that became an ongoing liability, that a company that makes just shy of $10 billion globally would pass on that to ultimately down the chain to consumers, when other companies that also extract large profits in the state are required to pay their payroll tax and don't, sort of imply that they're going to extract that down there.
So the amount my colleague referenced is what we pay in relation to the employees that we have in our Sydney-based head office. So no, I wouldn't interpret it to say that we will pass on that 7.2 in consumer
pricing. But if
pricing.
that liability is extended to drivers?
Yes.
Okay.
Then it is potentially possible.
Okay. So in terms of, I guess, you were here, I understand, for the conversation with the previous witness, for the exchange with the previous witness. So in terms of, I guess, social licence to operate, which, Uber's had a bit of a mixed history about in various places around the world, I guess, is there a sense that, an appropriate amount of tax for the profit that the company makes should be contributed to the community from which you extract those profits?
I think in terms of our social licence to operate, Uber has taken great strides in recent years. As I said, we were big advocates of the federal reform to bring in place minimum standards for delivery people, and soon this week I believe the process will kick off for rideshare drivers. So I think we have come to the Australian market with a recognition of how we need to operate and what some of the expectations are. I would push back on the concept, though, that an obligation on Uber's social licence to operate means we should operate in an environment where we are subject to a tax that our competitors are not.
Okay. It's an interesting position for Uber to take because Uber came into a market and began operating in a way that their competitors could not. So it's an interesting change of heart that you've had, and I'm pleased you have had that change of heart. I wondered if you could tell me, you talked about multi-apping. How many competitors do you now have in Australia? Because I understand Ola is gone. So how many other apps are there for Uber drivers to multi-app on?
I don't have a full list. DD would be the largest competitor. There are others from time to time. As you said, Ola has pulled out of the market. Sheba operates at time to time. I understand they have some challenges as well.
How much of the market
That's my next question.
How much of the market would Uber control in terms of rideshare?
I mean, taxi is still a sizable proportion of the market in New South Wales.
But of the
rideshare,
of the
as opposed to
rideshare
taxi.
market in New South Wales.
I think we'd have to take that question on notice. There may be some commercial sensitivities around that.
Okay.
Thanks, Chair, and thanks to you both for coming along. I wanted to ask about app sharing as well, as referred to in your submission.
Yep.
And you say in your submission, I can't see page numbers actually, but you say at the bottom of one of the pages, however, as Uber does not seek to restrict or control the ability of gig workers to source work across multiple platforms, Uber does not require gig workers that use our platform to provide information on their use of other platforms to source work.
Correct.
And I was wondering, are you able to tell us what percentage of your workers get the majority of their work from Uber?
Well, we wouldn't track that number because we don't have access to their total taxable earnings that they lodge with the ATO at the end of the year and then compare it to what proportion of that earnings is with Uber.
So you presumably have information about how many hours each of the drivers is doing with Uber, right?
Yes.
So wouldn't you be able to extrapolate from that in terms of the higher limit being the amount of hours that you could do safely in a week, for example, and then minus that from the amount of hours that your drivers are doing?
I mean, a large proportion of drivers are part-time or work fewer than 20 hours a week, so that methodology would fall over straight away. But to go back to my earlier point, that's a very awkward and complex and cumbersome way to work out if an exemption applies to your business that allows you to not pay payroll tax.
So that's why the market share is quite pertinent then for us to
I think it's also worth noting when we say multi-apping, that doesn't necessarily mean that a driver is, say, online with Uber for an hour, goes offline and goes online with DD for an hour. There are many drivers who you may see running two phones or both apps simultaneously. Including taxi drivers. So even though our hours might say a driver has done 15 hours in a week, that doesn't mean they have done. It doesn't give us any way to conclude how many hours they may have done with a competitor.
So is your evidence that Uber's done no surveys or information collection or analysis to look at that question of what percentage of your drivers getting what percentage of their work exclusively from Uber or majority from Uber? You've got no idea at all?
We have survey data, and I can undertake to provide the exact numbers on notice, but we have survey data that ranges anywhere from sort of 50 to 60% of drivers who will multi-app. But we don't.
Sure, but in terms of percentages I'm talking about.
We've not asked that question, no.
So there's no such survey or analysis being done by Uber ever, to your knowledge?
No, not to my knowledge.
So can you take that question on notice in terms of whether anywhere in Uber in Australia there's that information?
I can do that.
That'd be good.
And sorry, if I can just add to my colleague, we would never want to discourage drivers from feeling like they could multi-app, which is probably why we would not ask that question. And there's also antitrust laws that we have to comply with because we're subject to competition law in respect of sourcing independent contractors, so we do have to be careful about the types of information that we collect.
Sure, but why would a sort of survey expressed in neutral terms have a chilling effect on drivers' willingness to use other apps?
They might. There are all sorts of rumours that go around in the driver community. They might think that we're tracking them or that we have an issue with them working on other apps. It's also just not a question we have a lot of interest in because our business is premised on drivers having flexibility and freedom. So sort of would be the antithesis of our sort of business model to be asking those types of questions.
So do you require drivers to give undertakings that they're not driving above a maximum amount of hours per day or week?
We do have requirements in our contracts that drivers comply with fatigue limits, and we also enforce fatigue limits on our app.
So couldn't you use that fatigue limit to get a sense of how many drivers, for example, are doing a certain amount of hours per day or per week, and then look at that in light of the fatigue limit and get a pretty accurate sense, at least in respect of a significant cohort, of what percentage of work they're doing exclusively for Uber?
I think we would have to specifically ask them, how many hours have you worked this week for one of our competitors to be able...
No, that's not what I'm asking. I'm asking the opposite of that. So, I mean, I don't know what the fatigue limit is, but let's say it's, 12 hours a day or 16 hours a day, and then you've got a driver who is doing 8 hours with Uber or 10 hours with Uber, then presumably if they're complying with the contractual obligation, then they're doing, significant percentage of their work with Uber, and you could work it out.
A driver who's doing 8 or 10 hours a day wouldn't hit our fatigue limit.
Yeah, I know, but it would also mean that if they were complying with the fatigue limit, they couldn't do, as a percentage of overall work, much more work through share apping, correct?
We also, in New South Wales, I might have to take this question on notice, but in New South Wales, we track how much time a driver is online as opposed to on trip. So if someone has the app open for 12 hours, or 13 hours, their 13 hours of driving time would then max out, irrespective of whether they took a trip or not. And during that time, they could obviously be doing trips for one of our competitors.
Yeah, so it just seems to me that your submission is at pains to paint a picture of a majority of gig workers involved with Uber using a diversity of apps, not just Uber. But you don't seem to have done any work to present an accurate picture about what percentage of your workers are doing a majority or a large majority of their work exclusively with Uber.
The point we're trying to make is that the exemptions are not fit for purpose and they're administratively cumbersome. And it comes back, I think, to our original point that we operate in an industry that has traditionally been able to rely on exemptions, whether that's the taxi industry, which has a wholesale exemption under the services to the public exemption, which is not being applied to rideshare, whether it's our Uber Eats business, which currently falls under an exemption for delivery of goods that many companies across New South Wales will be relying on. I suspect there's a number of courier companies with very large independent workforces that are relying on that exemption to not pay payroll tax in New South Wales. That was the point we were really making, which is we do have a bona fide independent contractor workforce, and the fact that we would have to jump through all of these hoops, doing surveys, doing audits, asking drivers to fill out a form at the end of the day telling us how many hours they've worked for a competitor to then rely on an exemption would be incredibly cumbersome for us.
Sure. Thank you.
Mr. Rath.
Just following on from Mr. Lawrence's questions, my understanding is, and I'm not sure if you have any data you might be able to provide to us on notice, is that the number of hours driven by taxi drivers is far higher than the number of drivers with Uber, and that a lot of people that do use your app are actually part-time. They might have another job, whereas taxi drivers is often their sole source or predominant source of income, which often isn't the case. I don't know if there's any information you can provide to us on
Take that?
Yeah.
I am happy to provide that on notice. We do have survey data which will show the number of drivers who have full-time or part-time employment, also the number who perhaps run their own business or are studying. So I'm very happy to provide that survey data on notice.
Just to add to my colleague, taxis obviously also sort of purchase the car for a shift. So the bailment model essentially is they have the taxi for a 12 or 13 hour shift. They pay a fee to the taxing company to have access to the car for that 12 or 13 hours. So they've got a sunk cost from minute zero before they've even started driving. So they have to obviously drive for a certain number of hours to make back that fee that they've paid, and then after that they might keep what they earn, or depending what sort of model they're using. So our understanding is it's not really a part-time business model. You have to drive for the full 12 or 13 hours because you've paid for the car for that period of time.
But also taxi drivers, there's a taxi contract determination in New South Wales, which is different to the arrangements between Uber and Uber drivers. So there's a different arrangements with regards to minimum payments and that kind of thing. So that's fundamentally...
I agree, but I would note that the taxi contract determination in New South Wales is an instrument that has been not updated in, I believe, 12 years and does not contain any minimum rates of pay.
But there is, that's still a difference.
It contains an amount that the driver needs to pay for the vehicle. It does not set any minimum earnings floor for the driver.
Just one fine one.
Yeah, sure, before I go to Mr. Namber.
Just on the previous line of questioning, it's not, wouldn't you agree, it's not really a fair comparison to say what proportion of the rideshare market you have when your main competitor is in fact the taxi industry?
Correct.
Like, how's that even a relevant statistic, given that it is a competitive market because of taxis being a key component and competitor within that market, regardless of what other apps might exist in terms of rideshare? Isn't that the better determination of how competitive the market is?
I would agree with that assessment, and I think that goes to the point we made at the beginning where the exemption that taxi gets for rank and hail is just sort of neatly extrapolated over to the booked trips where we are directly competing with them. So yes, I would agree.
Just before I go to Mr. Nanva, just who does anyone log across platforms and across like rideshare or taxis the cumulative time that people are driving to make sure they're not doing 12 hours with one app and then doing 12 hours driving, like doing a 24-hour shift, driving a taxi and then driving for Uber or for whoever?
I don't believe so.
So a driver could go out there and do 12 hours for Uber and then do 4 hours driving a taxi?
The point-to-point commissioner is the individual or the entity who is responsible for regulation of the point-to-point sector, including fatigue management.
Okay, Mr. Nanva.
Thanks, Chair. A couple of my questions have since been answered, but I've just got a few more. Are there any substantive differences in Uber's business model in Australia as opposed to New Zealand?
You want to take that one?
It's the same sort of business model?
It's broadly similar, yeah.
Has the independent contractor argument been accepted in New Zealand?
You want to take that one?
By the courts, no.
So they're considered to be employees in New Zealand?
4 individuals in New Zealand were found to be employees by the Supreme Court of New Zealand, yes.
Right. Just for the sake of clarity, I just trying to get to the bottom of the main contention that you put into the committee today. Is it ostensibly that Uber should not be subjected to any payroll tax or payroll-like taxes, or is the contention that you don't question the legitimacy or the equity of governments collecting that sort of revenue, but you seek greater clarity in the application of those taxes to work arrangements that are facilitated by Uber?
I think it would go back to the point we've seen a lot of other made in a lot of other submissions, where the original intention of payroll tax is a tax on employee wages, and the intention was that bona fide contractors are carved out. I think our point is, and through engagement we've had with other levels of government, we would submit that the drivers, rideshare drivers, and our food delivery people are bona fide contractors, and therefore the legislative arrangements here are not keeping pace with modern forms of businesses and need to be updated.
Would you accept, though, as a matter of equity, whether you call it a payroll or a wage tax, a tax of that nature as a matter of equity should apply to Uber, or it shouldn't?
Equity with whom?
Well, other businesses with a not too dissimilar model to Uber are subjected to payroll taxes. So I guess the analogy I've got is you've currently got a major evolution going on in the nature of work, in the economy and in technology, where the law hasn't kept pace. Changes are obviously made to ensure that as a matter of equity, arrangements are captured so that people pay their fair share of revenue and taxes. So if you take road user charges, the fuel excise tax doesn't apply to EV vehicles. It couldn't have been conceived at the time of the fuel excise that EV vehicles could become a thing. So there will now be a road user charge that's implemented to ensure, as a matter of equity, everyone is on the same playing field. There is an argument that Uber has been operating in an environment where there hasn't been a level playing field. And I'm just interested as to whether or not you believe that Uber should not be subjected to taxes of the nature of payroll taxes, full stop.
I think my response to that would be, I've not seen any evidence that there's a proposal to extend payroll tax to contracting more broadly. And so, for example, as my colleague mentioned earlier, for our delivery business, there is currently a carve-out for the delivery of goods, which applies to us. It also applies to all of the other traditional players in the delivery space or in the courier space, for example. I've not seen any proposal that says we should be extending payroll tax more broadly to those kind of contractor arrangements as well. So I guess it's hard for us to respond when there's not kind of a proposal on the table more broadly.
Can I just jump in quickly? And it goes to the question I asked earlier as well. I understand what you're saying. There isn't a direct proposal, so it's hard to respond. But I wonder, particularly given your role, Ms. Brunner, if you could then describe what Uber feels like it should be contributing to the sort of general benefit of the state of New South Wales, given that it conducts work here. I've just wondered if it does feel, and it may not, and you may say none, but I just wondered if it feels that there is any sort of obligation to give back, to contribute to, as others do who pay tax, maybe in different circumstances, maybe for different reasons. But does Uber feel that it should be in the communities that it operates in, contributing to their good functioning?
I would say consistent with other businesses who undertake similar forms of work.
Isn't it the case? Is it the case that you say you should get the same exemptions as that apply to the taxi industry?
Correct.
Correct.
If the taxi industry gets an exemption, then you should get an exemption.
Correct. There's no, in our view, there's no principled reason to exclude an independent contractor transporting goods and an independent contractor transporting a person, especially when taxis are exempt.
And that really is the level playing field that you're
Correct.
looking for in relation to
Correct.
this outcome.
Correct. Noting that we do pay payroll tax in respect of our employees in New South Wales, and obviously we're a significant contributor to the broader tax system through taxes that we pay to the Commonwealth.
And I take it your position is not that you shouldn't comply with the law.
Well, they've got a mixed history on that, Damien. So
Can I ask you? Can I ask you this? The situation is that Uber does control the manner in which drivers choose where they work.
No, there's drivers can choose to work wherever they want, as long as they're within New South Wales.
Well, you can deactivate drivers.
Correct.
There's a level of control there over the.
Well, we obviously we don't deactivate drivers for no reason, because we have an interest in having drivers on the platform. But we can't. Well, any principal who engages independent contractors can terminate the independent contractor in accordance with the contract.
And you apply ratings thresholds.
Correct.
Correct.
Yeah. And you use algorithmic constraints in relation to drivers, do you not? You monitor the algorithms of the way the drivers are performing?
Not to control how work is sent to them, or whether or not not to control how work is sent to them.
What do you use it for then?
So
We use the
I just wanted to know, not for that reason, so I just wondered.
well, we use the algorithm to try and match the best driver with the best rider. So if you've used the app before and you order an Uber and the car shows up on the right side of the road, which is particularly outside on Macquarie Street, that's all part of the algorithm that we use to try and have a smooth service. That's not a coincidence that your car might be on the same side of the road as you. That's the type of algorithmic sort of control that we would implement.
And when you use it for the purposes of fare structures and the like, do you not?
The fare is set by an algorithm, but by reference to a time and distance rate card.
Because effectively, what the principal argument you use is that Uber acts as a digital platform, which is an intermediary,
Correct.
rather than a direct employer. Well, except that there are some aspects of the relationship which don't fit neatly within an intermediary definition, by virtue of the fact that you can deactivate and.
So we obviously deactivate to ensure safety on the platform, and we're also a regulated business in respect of our rideshare business. So we have an obligation to ensure that the drivers who are on the platform, comply with our regulatory obligation to provide a safe service. We also set prices on behalf of the drivers, and that's to ensure that the marketplace functions. The alternative would be to allow drivers to charge whatever they want, which I think we've potentially seen at the Sydney airport with taxis. It breaks the marketplace immediately. If you didn't know how much the driver was going to charge you for a particular trip,
You wouldn't use it.
You wouldn't use the app.
Yeah.
And it's consistent with many forms of contractual relationships. Franchisees are very similar. There's generally a pricing structure that's applied so that when you go into a McDonald's, you know what to accept. There's some form of pricing uniformity.
Mr. Lachlan,
Is a passenger...
Sorry, before I come to with your apps, you have ratings. So a driver can receive a rating, a performance sort of indicator. How does Uber use that information? Does that guide how that person, what work that person is given?
It's sort of used it's used for riders. So when you are a rider and you request a trip, you can see the rating of the driver. Many riders will choose to cancel the trip and re-request it if the driver's rating is too low. because they may believe that the low rating is indicative of a lower level of service. And if a driver's rating drops below a certain level, they will be warned. And if the rating does not improve, they may be deactivated.
Mr. Namber?
So I was just going to ask, is a passenger entering into a contract with the driver or with Uber?
They are entering into a contract with the driver.
Directly with the driver?
Correct.
Questions, colleagues?
Can I just,
Mr. Tudor-Hope?
You'd agree, would you, that if in fact you are successful, or that your argument is successful, would the argument that you raise that then apply across the board to labour hire, courier platforms, care platforms and other logistic type apps that are currently available in the marketplace?
Well, I believe some of those platforms would have the ability to rely on the exemptions. I would have to take that question on notice. I'm not sure of the downstream implications of us succeeding on our arguments in relation to what's a relevant contract.
Done? Any more? Mr. Nanva? Good. All right. Well, thank you very much to Uber. That was super. We very much appreciate you making a submission, appearing before the hearing today, providing information to the inquiry. There were some matters taken on notice, which the Secretariat will be in contact with you about in due course, seeking an answer. We've extended the time because of the Christmas break into January for those answers to be provided. But thank you very much for appearing today and providing the evidence that you have.
Thank you.
Thank you.
Thank you.
Thank you. Clark, thank you very much. Before we commence, if I could get you to state your name and position title and swear either the oath or affirmation, and I'll start with you, Mr. Nyland.
My name is Liam Nyland. I am the Head of Government and Stakeholder Relations at Mable Technologies. I'm giving the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Ms. Clark.
Hi, my name is Emma Clark and I'm the Chief Financial and Operations Officer at Mable Technologies, and I'm also giving an affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Do you have an introductory statement you'd like to make to the inquiry?
Yes, I do.
Please fire away.
Thank you, Chair and members of the committee. Mable is a health tech platform that offers a complementary approach to traditional aged care at home and disability support models. Mable gives older Australians and people with a disability more choice, control and flexibility to shape the care and support they receive in their own homes and in the community. This choice is made possible by over 21,000 independent contractors providing valuable and necessary care and support services via the platform. Founded in 2014, Mable now operates at some scale, with support providers on the platform providing care and support services to over 28,000 people with a disability and older persons. Since its founding in 2014, 25 million hours of support have been provided via the Mable platform. On Mable, independent contractors set their own rate of remuneration, find their own clients and write their own contracts. Contractors on Mable have high bargaining power on negotiations relating to services contracts, are paid on average more than their employed counterparts, and have a high degree of authority over how they perform their work. Like all companies, Mable pays payroll tax on behalf of its employees. The Attain Health Tech Group, of which Mable is part, paid $1.71 million in payroll tax in the last financial year. It is the strong view of Mable that the Payroll Tax Act 2007 does not apply to arrangements between clients and support providers using its platform. Even so, Mable is aware of attempts by the New South Wales State Revenue Office, or SRO, to capture more contractors working in the care sector. Over the past year, a number of Mable's competitors have been audited and found liable for taxes that had never previously been charged on contractors working in the care economy. This position is supported by Mable's 2022 audit by the State Revenue Office, which identified no issues with the independent contractor arrangements on the platform. Perhaps for this reason, Mable has not yet been approached. Mable's strong view is that the New South Wales Government should not seek to capture independent contractors working via platforms. In Mable's view, any such action would harm workers, stifle competition and reduce safety for clients. Approximately 90% of all funds flowing through the Mable platform come from the federal government through the NDIS and Support at Home programs. Imposing a state payroll tax on these arrangements would mean federal taxpayer money intended for care recipients and workers is being diverted to cross-subsidise the New South Wales government budget. Mable's platform fee is 16.6% of the transaction value. A 5.45% payroll tax liability would represent 1/3 of Mable's entire revenue base. It is financially impossible for Mable to absorb this cost. The inevitable result would be reduced remuneration for independent contractors, reduced care hours for older people and people with a disability, and increased cost to the federal government. Mable's primary competition comes from off-platform independent contractors operating directly with clients. Any move to impose payroll tax liability on platforms would create a significant competitive disadvantage for platform-based arrangements, despite the fact that platforms offer enhanced safety through verification and background checks, complaints and resolution mechanisms, insurance coverage, and NDIS and aged care compliance support to independent contractors. The perverse outcome would be to push independent contractors away from safer, more transparent platform arrangements back to informal, unregulated direct engagement. There is a simple solution that would protect care workers and recipients in New South Wales whilst ensuring appropriate use of taxpayer funds in New South Wales. The New South Wales Bulk Billing Support Initiative recognises that government funding for healthcare should be directed towards service delivery and practitioners rather than being diverted to administrative costs and taxes. Mable proposes a broad-based exemption for all independent contractors in healthcare providing taxpayer-funded services. This would apply not only to platforms but also to allied health practitioners in practice models, nursing contractors and non-GP doctors working in practice models. An exemption would not result in any substantial loss in revenue. It would, however, minimise the impact on primary care by not exacerbating workforce challenges and help prevent hospitalisations, thereby preventing a reduction in hours of care received by older people and people with disabilities. A reduction in care could lead to hospitalisation of those clients. I am grateful for the chance to appear and welcome your questions.
Thank you very much, Ms Clark. The opposition?
So, I understand your submission is not so much that you're not liable to pay tax, but that you shouldn't have to pay it because you're a healthcare provider. Is that the thrust of your submission?
Well, the main thrust of our submission, thank you for the question, is that we believe that contracts that are established on the platform do not meet the definition of a relevant contract, so therefore the Payroll Tax Act does not apply.
But even if they did, your secondary submission would be?
That effectively this is just going to increase costs to the client in terms of reduced hours of care, or the independent contractor is going to have to reduce the rates that they charge, and it's government money primarily, as I said, 90% from the NDIS and aged care.
So you'd be encouraging a recommendation from this committee to provide an additional exemption for contracts
where it's taxpayer funded.
Yeah.
Yes.
So if in fact, for example, the Uber decision went against Uber, and they were found to be an employer for the purposes of Payroll Tax Act, you could potentially see an argument that the same sort of arrangement would apply to Mabel, because they are a platform-based employment provider, that in those circumstances you may have a liability for payroll tax, but then you would want an additional exemption because you're a frontline healthcare provider in the sense of enhancing the benefit of healthcare opportunities in the community.
Correct.
Yeah.
The only clarification I would probably add would be that I don't want to speculate on where the decision with Uber might go. Obviously, that's a matter for the courts. I'm not a lawyer. But there are still quite substantial differences between how Uber contracts and how platforms like Mabel contract.
Well, let me explore that. Just to explain in some detail just how the Mabel contract exists between the consumer, I suppose the aged care resident, potentially an at-home aged care resident or the like, who uses your services. Just explain to me how that operates.
So it operates slightly differently across NDIS and aged care. Would you like me to provide an example of an aged care recipient? Yep. So I always use the example of Mavis. She's a mythical person, but just to put a face to a name to the face. But effectively, Mavis gets a support at home package from the government. She has to engage an approved provider, now called a registered provider, under support at home to administer that package, and that registered provider is responsible for setting up Mavis's supports and also overall her clinical wellbeing. They charge a fee for that. As part of that, Mavis may choose to self-manage her package, and as a result she may choose to advertise her own jobs for who comes into her house. So let's say she wants someone to come in and provide some domestic assistance a few times a week. So she'll come to Mabel, she'll onboard to Mabel as a client. She will then create a job for someone to come in for 3 2-hour shifts a week and say what she's looking for and where she's located. She'll either post that job onto the platform, and then independent support workers will effectively say, hey, I would be interested in doing that work with you. Or she may actually search for workers in her area and then send a worker a message saying, hey, I've got this job that I would like you to come in and do for me. Would you be interested?
So it's like Airtasker.
Very, very similar to Airtasker. So we could call them horizontal platforms, so very similar. So Mavis then might have some meet and greets with some people who are interested or that she's approached. She'll end up selecting her person. So Mavis is absolutely selecting the person that she wants to come into her environment, help support her. When she does that, she and that independent support provider then negotiate their own contract. So the independent support provider will normally, when they've onboarded with Mabel, provide indicative rates for services that they're both qualified and wish to provide, and then Mavis will engage with that person through Mabel, set the rates, set when the shifts are going to be, and also direct the support worker directly on what's to be done during those shifts. What Mabel does is host the agreement, and then facilitate the ability for the support provider to enter their support session that they've had for Mavis, and then facilitate the flow of payments through the platform.
So who does Mavis pay you, or does the government pay you?
The registered provider that Mavis has appointed pays Mabel's invoices.
Pays Mabel,
and Mabel's invoices go to that.
Mabel, in fact, pays the contractor.
Correct.
Can you elect not to take on a contractor?
Yes, so on the independent contractor side, so at the moment approximately 1,800 people sign up to Mabel a week wishing to be an independent support worker on the platform. Of those, approximately 700 a week get approved, and approximately 300 of those enter into an arrangement with a client. And the reason that 700 are approved of the 1,800 that have signed up is because there's relatively stringent verification processes before they can actually be approved to seek work through the platform. So that's, at the moment, we've recently migrated to the NDIS worker screening check, so people need to have an NDIS worker screening check that's valid in order to be approved. And then there's 32 services that a contractor can choose to provide through the platform. Some of those require qualifications and some of those do not. Where they require qualifications, we need evidence of the qualifications. So it's a relatively robust process, multi-step, takes a little while to onboard an independent contractor, and they have to meet all of our verification requirements.
So the relationship between you and the contractor is one where they've got to be approved by you and they're paid by you.
Yes, correct.
So if there is a complaint by the end user, by Mavis, about the service that she is receiving, in those circumstances, can you in fact terminate that arrangement with that contractor?
Yes, so we do have the ability to ban a worker or ban a client, and in the vast majority of cases that is because of an incident or a complaint, or where something has gone quite wrong and it's for a health and safety reason. And so yes, one clarification on the payment side of it is the contract is struck between Mavis and the independent contractor. If the invoice is unpaid by the registered provider, that is, Mabel will help try and facilitate those payments to be made, but Mabel is not liable for the payment to the contractor because we're not a party to the actual agreement. So we will best endeavour and make all efforts to try and find out why that invoice hasn't been paid and recover payment, but we are not liable for the payment to the contractor, which really is at the heart of our model, which is these independent contractors are running their own businesses and they are contracting directly with the client, and so the liability is between the client and the independent contractor.
What would it mean for Mavis if you did have to pay payroll tax? Would it mean higher a price charge to the end user?
So I'll take this one, yeah?
Yep.
Just conscious I'm doing all the talking, sorry, Liam.
You're the Chief Financial Controller, it's a good question for you.
So it could manifest in one of two different ways. Mm-hmm. So either the contractor themselves, so I'm trying to think of the simplest way to answer the question, because once again it depends on the regulatory environment in which this is occurring. So with aged care, it is more likely that the contractor would keep their rates to what their rates are, and we would have to apply 5.45% additional charge on top of the invoice, and that would mean that each hour of care for Mavis is costing more, and therefore she would get less hours of care in her package.
And I notice you're not making super profits exactly. You're sort of struggling to break even at the moment, so
yes,
it couldn't come out of profits.
No, look, couple of comments on that. So I did actually ask, for a completely different reason, about 6 months ago, how much has Mabel invested in the platform over the 12 years that we've been in operation, and it's north of $300 million, which is why we haven't made profits. So technology business, lots of, there's 350 odd staff in Mabel, helping do features all the time.
Like almost every startup in Sydney.
Exactly. So, and obviously we're paying payroll tax on all of those.
Yeah.
But effectively, no, we've done 10 years of very solid investment. And so I know in our submission from a year ago, we did talk about the fact that we were loss-making. For clarity, in the FY25 accounts, which we lodged in September, we're part of Attain Health Tech in terms of from a Mabel perspective, and that did actually post a $1.1 million profit. Mabel Technology was still a $1.1 million loss in the last year.
Are you living in fear, so to speak, that at any day you could get correspondence from Revenue New South Wales saying, please pay payroll tax retrospectively? Because you're not currently paying it now. You're one of the stakeholder groups that we're hearing from that hasn't yet been hit with that invoice, so to speak. Is that a real concern, or have you received like guidance or clarification from them, and it essentially hasn't been answered? What's been the relationship between you and Revenue New South Wales, if any?
Nothing since 2022. So as I said in my opening statement, we had an audit with them in 2022, and there was no questions raised about independent contractors on the platform at that time. So that audit was fine, and we haven't heard from them since. In terms of your first question, does it keep me up at night? Yes, because do we have the ability to pay it when we're a 16.6% margin, particularly if it's back levied? No.
Yeah.
Dr. Kane.
Thank you. Thank you for appearing and for your evidence. I've got some follow-on questions from what we've already heard, just about how you do your work. And so Mabel, the client pays Mabel. So Mabel is the one that issue invoices?
Yes.
And are they branded as Mabel, or are they, how does the individual know it's coming from? Is it Mabel branded?
Yes, so the invoice is Mabel branded. It's actually issued by a subsidiary called Mabel Payment Services, which is part of the group. That's been the case ever since we were established. I mean, I think it was a couple of years after we incepted that we used Mabel Payment Services as agents. So they're done by Mabel Payment Services, but yes, the invoices are Mabel branded.
Mabel Payment Services. Is that a separate business?
Yes, it is.
Okay. And I presume the email is from Mabel Payment Services when the invoice gets sent. Okay. And you mentioned debt recovery. So do you undertake? You're not liable, but you undertake debt recovery on behalf of the contractor.
Yes, it is. We attempt to. Yes, it is in everyone's best interest for the flow of funds to be, as we know. If you think about workers working in the care economy, there are structural shortages. We obviously want more and more people to be able to work in the care economy. If they aren't getting paid for the services that they're delivering, needless to say, they won't want to work in the care economy. So it's in everyone's best interest that we assist them where possible in those debt recovery efforts.
Yeah.
If I could just add to that, Dr. Kane, might be helpful. I guess one way to think about Mabel is as a series of business tools, and keeping in mind the vast majorities of independent contractors that work in the care economy actually operate off-platform. They contract through Facebook or through word of mouth. So in terms of why an independent contractor might choose to come and use Mabel, part of it is to overall reduce the risk of non-payment, although not prevent it altogether. Ultimately, there is always in the care economy a risk that an independent contractor will not be paid. And this is one of the fundamental differences and the choices people need to make when they're deciding whether they want to be an employee in the care economy or an independent contractor.
Can I ask about that? So part of the way that the NDIS is set up is so that clients can individually manage, should they wish. They don't need to have a support
A registered
coordinator.
provider, yes.
They can do it themselves. So, I mean, whether or not you think it's a good thing, but there is an intent in the policy that there is the ability for workers to be engaged directly by individuals, to cut out any middleman, so to speak. So when you're, I guess, raising that as a concern, I mean, that's not really a concern of us for payroll tax. That's really an issue for you to raise about how you think care should be conducted through the federal government's NDIS scheme. It's not really a direct concern for us. That's about how care's delivered.
Well, if I might, Dr. Kane, I would point out it is a joint scheme. Both New South Wales and federal government have a stake in the NDIS. And obviously people have lots of differences of opinions about how people engage through the NDIS. And certainly we're not actually saying that off-platform should be prohibited or anything like that. We're just pointing out that there is a higher risk associated with that. And I think also given the New South Wales government has been involved in initiatives to, for instance, prevent fraud within the NDIS, I would argue this is a joint concern of government.
Okay, I mean, we could argue about that.
I would just add that I don't disagree with what you're saying. I think our point is more that it's anti-competitive, and whilst we definitely don't want to force people to use platforms at all, and if you think about Mabel, the business, in terms of the hours of support that are being delivered, are pretty evenly split across disability and aged care. So there is, obviously disability is half of the business that's flowing through the platform, and none of those people are being forced to use Mabel, so clearly they're seeing value in the safeguards versus contracting directly. I think it's more just that imposing an extra 5.45% on Mabel and off-platform is not having anything imposed upon them just creates competitive pricing challenges.
I mean, when you talk about anti-competitive or levelling the market, I mean, there is another model, isn't there, which is direct employment, which does then attract payroll tax. So it's not as if there was off-platform and platform and no other opportunity to engage in the market. There is also, an option is a direct employment model. Clearly it's not Mabel's business model. So it's not like there's just the one or the two. There's an off-platform, potentially less regulated, potentially more dangerous. There is competition in the market in terms of business models as well, isn't there?
Absolutely, and we would contend, and I'm pretty sure we said it in our submission, that there is room for all models. Like, we're not arguing that all models should be like Mabel. We also don't think that others should argue that all models should be like theirs either. I think there's room for everybody in such large schemes. The point I'd raise about the direct employment models is, generally speaking, they're charging a much higher overhead. So the difference between what they're paying an employee in those instances versus what they're charging the client is running at more like 30% rather than Mabel's 16.6%. So,
which is a protection for care workers who we know are some of the worst paid in the economy. So there is a benefit there, which we see beyond the price. So we probably don't want to get into that. But
you also set up your business. Just a point of clarification: you set up your business model expecting that you wouldn't have to pay payroll tax.
Absolutely.
Like, if you knew you had to pay payroll tax, then maybe you would have gone down the direct employment model. But that wasn't a consideration at the time when you set up Mabel. Your expectation, the costs that you looked at, was that payroll tax wouldn't be a part of that.
Well, our view is these are genuine independent contractors. Their average hours on the Mabel platform is I think in the submission we said it's currently 9.2 hours per week. And so, no, we hadn't thought about payroll tax when we set up the business back in 2014. And our pricing models assume that, really, the business was set up to enable more hours of care to be delivered to people, and they get to choose the person that comes into their home, and those people end up earning, a good rate of remuneration for their independent contracting work that they're doing. That was the ethos behind, and the pricing models that were set up at the time.
Can I just clarify a question from Mr. Rath? So you set up, or the business was set up, sort of understanding that it would avoid payroll tax by a set of arrangements which meant that workers could be viewed as...
No, absolutely not. Right. The business was actually set up, and I won't occupy too much time with my answer here because it's a long story, but it was actually set up by one of our co-founders who had his mother was suffering with illness, and he was with a traditional model, and they were sending different people to his mum's house every day, and his mum was getting very upset about that, and his dad was getting upset about it as well. And he was like, surely there has to be a model where my mum could actually pick her person to come into the house and provide care and supports. And obviously at that time, traditional employment models did not offer that kind of flexibility. So that was the driving ethos behind setting up Mabel. Payroll tax was not a consideration at the time.
Right, okay. Could I ask something about your fee structure for the contractors? Because you're not paying, point is you're not paying payroll tax at the moment, are you? You've said you've been audited, you're not paid. So Mr. Rath's question about you weren't expecting to pay payroll tax, or you haven't paid payroll tax?
Other than on our own employee base. Yes, correct.
Okay, so that is not in question at the moment. But can you explain what fees Mabel takes in terms of contractor and what language to use, but what you provide for that fee?
Do you want me to?
Yeah, so the fee amounts to 16.6%, but it's actually charged in two increments. I'm an arts graduate, so I tend to use whole numbers when I try and explain this to people. So if you think of if someone was billing at $100, which is a bit above the most averages, then the total paid by the client would be $107.95, and of the amount, the set rate by the independent contractor, Mabel would take 10%. So if you add the $10 from the 100 and the $7.95, divide that by $107.95, you get 16.6%.
So the contractor receives $90. Yeah.
And what do you do apart from, so if we were thinking, I think Should Hope compared it to Airtasker, but what else do you provide for contractors for that fee, apart from the platform to connect? Is there anything else that you provide?
Yes.
Yeah.
So there is a learning hub with 170 different courses, which are available to all independent contractors. There is a suite of group insurances. So there is income protection insurance, which is included as part of a personal accident package. There's professional indemnity insurance, which includes medical malpractice, and there's public liability insurance as well. So those are all for all. So any service delivered through the platform that is not, the only way to avoid that insurance is to commit fraud, for example, but otherwise all services delivered through the platform are covered by those insurances. There's also services like counselling, there are tax advice which is provided by an external provider, and of course there's the invoicing. There is some level of opt-in guarantee of pay, so there are 2 separate programs that are available for that we could talk you through, one of which is an invoice factoring service. But I think overall the thing that people value is the trust and safety. So if you think about one of the biggest risks for workers, particularly in the NDIS, but it also obviously exists on the client side and in aged care as well, is the risk of some kind of harm coming to them. So both parties have the assurance that people are being screened and that people are who they say they are, and that if something goes wrong, there's a full-time trust and safety team there to support them.
Thank you. Can I ask a question about the insurance? What if a contractor came to you and said, I've got my own insurance, so I don't want that taken out as part of, can we come to an arrangement because I've covered that, I've got my own, or so do you allow for that kind of flexibility, and if not, why not?
No, because we have gone to the market and we've sought to get the best insurance available, and that is part of the guarantee to provide to both parties. So, it would be a difficult thing for us to offer an opportunity for people to opt out of that, and I'm not sure I would see the upside in that.
And also then, the client is utilising Mable because they know that there's that insurance coverage. And so if we say, well, there is that insurance coverage for 20,500 of the 21,000 contractors, actually 500 have their own insurances and they differ from, Mable's insurances in this way across 500 different policies. That just becomes very, very confusing for the client to understand what protections they actually have or don't have.
Okay, so it's a requirement of the contractor to have the insurance that you...
Well, it just comes with the platform. So to
well, it's a
Mr.
requirement
Arnold's
then, isn't it? You can't be on the platform if you don't sign up to that.
Yeah.
Yeah. Okay. Thank you. Thank you.
Thank you. Mr. Tudor-Hope, Mr. Nanvar, Mr. Rath.
It appears to me that a lot of the decisions that the courts make in relation to the assessment of whether an entity is liable for payroll tax is on the basis of what the substance of the agreement is between the, want of a better word, the employer and the, in your case, what you describe as the contractor. And it may well be that the rather than the fact that you use certain words to try and, as part of the agreement between you and the contractor, seek to alienate their responsibility from you as an employer and contractor. So rather than the form of those words, they look at actually the substance of what the arrangement is between you. Do you agree with the proposition that if you looked at the substance of what exists between you and the contractor, in substance, it looks like an employment contractor?
No.
You don't accept that?
No.
Not even
What do you
slightly.
say differentiates you from an employment contractor?
If I may, I'm not aware of any employment contract, Mr. Tudor-Hope, where a worker can set their own rate of pay, which is facilitated through the platform. Similarly, the contracts, the service agreement contract that exists is one that is written by the independent contractor and sent to the client. There are other things, obviously, you could make an argument that, for instance, casuals have the ability to dictate their hours of work, which is true, but there's no rostering element. That is all fully decided by the independent contractor.
Can I just quickly jump in? Sorry. Care workers in this part of the care economy, and I've done a bit of work in this, you're suggesting that care workers write their own contracts.
Yes.
Isn't it true that you have sort of a number of clauses that are mandatory, and would it be that then those self-written contracts basically just contain Mabel's mandatory clause? And this is no disrespect to any care worker, but their skills and qualifications are in giving of care, not in the writing of contracts. So when you say they write their own contracts, forgive me if I'm a little incredulous. I'm not entirely sure what you mean by that. And perhaps on notice you could provide to the committee de-identified examples of, you know, contracts that have been written, and maybe a number of samples, because I think it's a really interesting claim.
Yeah, and I would just say, Dr. Kane, obviously, I appreciate you haven't had the benefit of reviewing those, but a number of entities have, including, you know, the Fair Work Ombudsman, and they didn't share your incredulity or your scepticism.
Well, they've seen them.
They have.
Yeah.
In terms of how the process works, there are a couple of mandatory terms, one of which is, for instance, that you have to use the Mabel platform to process payments. However, otherwise, there are suggested terms which are based upon other contracts on the platform, but these are always provided as optionals. So we don't expect people to write it from scratch. No, some do. Some copy and paste over an agreement that they have off platform and choose to use that, subject to a couple of mandatory terms as well. Other people pick and choose the terms that are available and suggested, although, again, there's always options and suggestions. So it's kind of a supported process whereby people are encouraged, for the protection of the independent contractor, to consider things like a cancellation term, for instance.
Can I ask, if I'm a contractor, and so I'm managing the contract between me and the client, do I have the ability to substitute someone else to do my work for me?
In a theoretical sense, yes, but it is not something that has been formally, in terms of a subcontracting ability, it is not a feature that has been built into the platform, because to date we've never actually received a request for it. So it's something we have considered over many years about whether that's something that would be helpful for independent contractors and clients, but it is not something that is featured into the platform at this time.
So a contractor doesn't have the capability to outsource work to someone else that they were going to do. So it's not, that part of it is not within their control currently.
Can I add that that's in part to make sure that everyone is meeting the regulatory obligations that we have with both the Aged Care Act as a digital
But you're
platform
making sure that, because I'm a contractor, I could be just as compliant as you. I could make sure that whoever I contract to has the appropriate checks and balances. So that would be something I might want to take on as a contractor myself. But you're saying your model doesn't allow that type of...
At this time.
At this time.
But if we were to receive a request from an independent contractor to provide such a feature, we would seriously consider it.
Okay.
And the other thing I would add is, in terms of care contracting, it's largely a personal relationship. So the concept of, like, you know, Mavis has selected me, but I'm now going to subcontract in someone else. That's not the dominant.
But Mavis may trust me, and I say to Mavis, I just can't do that day, Mavis, but I want to make sure that you're covered because I care about you, and I have someone who I have, whatever, you know, I have vetted, and because we have a relationship of trust, that is something that could work. So it's, I guess there is a conceptual sense there that's a possibility, but at the moment you don't allow
and
that.
people are not requesting it. What is the more common pattern is, if that situation occurs, either the client or the support worker contacts Mabel, says, you know, the support worker says, I'm not available for the next 3 weeks, or the client says, you know, Dr. Kane's going away on a holiday, and Mabel will say, okay, let's do another job post for you and assist you in finding another worker.
Okay, I just want to summarise though, so I understand the relationship. And granted, all of this is within a context that you haven't been asked to pay payroll tax.
Correct.
So, you know, we're still talking that context, but I'm just wanting to clarify. So so Mabel controls invoicing, insurance, client allocation, policy compliance, and you determine whether someone can keep on working, I presume, because you could kick them off your platform if there's been some reason to. Is that right? All of those things are...
No, client allocation is not correct.
Okay.
So on Mabel, support workers must find their own clients, and clients must find the support workers. So the two paths that generally happens, I think I said this in one of the earlier responses, is when a client comes on, they may either, like, I might onboard as a client, as Mavis, and I may say, hey, I'm going to do a search for workers in my postcode. And then a list of workers comes up, and then I'll privately start messaging workers saying, hey, I've got something that I need some help with. Are you interested? The other way to do it is, as Mavis will...
Sorry, can I just confirm? But so it's still from the client looking for someone, and then you suggest people?
We don't suggest, we just, there are a list of workers. Like, if I was to if I was to type in my suburb, which happens to be Keilor East in Melbourne, so I was typing 3033, a list of thousands of, like however many hundreds of workers or thousands of workers are in that postcode, or say that they will provide service in that postcode, they will all come up, and then I can just look through this list of workers and decide who I wish to message. And then the other path is that I do a job and I actually post that job, like a job posting board, and then independent contractors will then like look at those jobs and say, I'm interested in actually providing that service, and they will effectively apply for that job. And then there'll be a place in the platform where I as a client can see all the people who've applied, and then once again I can commence a conversation with any of them. It can happen either of those ways.
I would also add that there is nothing to prevent an independent contractor from maintaining their own insurance policy in addition to the requirement to use the group insurance provided through the Mable platform. And indeed our understanding, well, it's not a question we've asked, but certainly in informal conversations we've had with many people, because most contractors that use Mable also either work on another platform where purchasing a policy might be a requirement as opposed to the platform providing it, or they work off platform, so they also do often have
I appreciate that, and I understand. It makes sense why they would do that. I was more interested in what your requirements are. So, you know, that's fine. It's understandable that they would engage in that kind
The basis of the insurance policy on Mable is based on the amount of delivered hours that are running through the platform. So when we engage in that policy every year, it's based on a certain number of hours being delivered. So it's just coverage across all the hours that are delivered on the platform. We obviously have to, you know, assert to the underwriter insurer that the people are appropriately verified to do the work in line with our verification policy.
People reviewed, providers reviewed on the platform, or like given a testimonial from people
so we call them star reviews. They're pretty rudimentary. At the moment, the last time I checked, which was a couple of months ago, approximately 4% of the independent contractors on the platform had a review. Most of those reviews were 4 or 5 stars. It appears on their profile, but it doesn't form any part of any matching or algorithm. It's just there as a trust signal if people wish to take notice of it or not.
Okay. Oh, sorry.
Have you ever sought legal advice about this arrangement, about whether it might be subject to New South Wales payroll tax?
No, not New South Wales payroll tax.
Or Victorian payroll tax? It was similar, I assume.
We haven't been approached by the Victorian.
So you
payroll tax.
haven't ever received legal advice in relation to this arrangement?
If we had I'm not a lawyer. To my mother's enduring shame, I never went to law school. But my understanding is if we had and we were to disclose that would have some implications.
Sorry?
If we were to state that advice exists, that's something that we would generally be advised not to do when we have previously received legal advice. But I'm not aware of any advice being received.
So I think I understand that if you have received it, you're not going to give it to us. But you're not aware whether you've got advice, is that right?
My understanding is we
Can
have
you take on notice whether you in fact have received legal advice in relation
Yes, we can.
to this arrangement?
Yeah, so we'll take that on notice and respond to you, the same as Dr. Kane's request for evidence of individual contracts that have been drafted
And
by...
could I just ask an additional, have you ever received advice about if you became liable for payroll tax, if that would have any implications for your employment model or any other obligations to workers in terms of industrial obligations?
I can absolutely confirm we have not received advice regarding any of that, no other implications.
And have you had internal conversations about that?
I'm not really aware of a way in which a payroll tax liability would have any implications for industrial relations.
I'm just wondering, we've been talking all day about the, multifactorial kind of characteristics which are not exactly the same, but there are echoes of it across the industrial relations system, across workers' comp, across super. I'm just wondering, it's just a logical kind of discussion to
Sure,
have.
but I would say that similar factors feed into those assessments,
Yeah.
but a determined liability in any given one doesn't necessarily
No,
have
of course.
implications
Yeah.
for others.
As Uber will attest.
And they are all somewhat different in terms of the Fair Work Act or any of those other potential liabilities.
Sorry, Chris, I jumped in.
No, it's not really that payroll tax specific, but I was just more interested with the NDIS and some of the problems that have been well ventilated in the media over the last 12 months or so. Is the platform that you run, does it give comfort to clients essentially that they will be getting a higher standard of provider, where some of the bad providers essentially are weeded out, where they don't need to navigate the NDIS website, that it's and they might end up getting a dodgy provider that I assume there's, as you mentioned before, these additional sort of checks beyond the existing checks that the NDIS already requires. You've got like an additional like standard above that. Is that one of the benefits that why people would use the platform?
So my point to that, which also was a point in one of Dr. Kane's questions earlier, is about half of the delivered care, like currently there's about $480 million a year of delivered care going through the Mable platform. About half of that is disability services. And to the earlier point about, in terms of regulatory environment and disability, a person can choose to contract off platform, through a direct employment arrangement, like a multitude of ways. Obviously, Mable's a low-cost platform, but there still is that 16.6% charge. And so the fact that you've got, $200 million worth of service delivery through the platform, I think is effectively proof that there are certainly a cohort of those 750,000 NDIS clients who very much value the protections that Mable brings because, frankly, they're prepared to pay for those protections.
Can I ask a question which is a little... it's related, but does Mable hire workers to, say, aged care or disability providers as opposed to individual clients?
I'd say that under no circumstances does Mable hire workers. That would be language of employment.
Sorry, say that again?
Under no circumstances does Mable hire workers.
No, sorry, if I didn't mean to say hire, but do you facilitate the use of Mable contractors to actually aged care or disability providers as opposed to individual clients?
Only where the registered provider is representing the client. So if we go back to our original example of Mavis and her getting her support at home package, Mavis must select a registered provider to administer her funds. So that provider, like at the invoice for that particular service, will go to the provider. So like a Uniting Care, for example, but for Mavis as the participant, and it's coming from Mavis's package. It's just the registered provider is effectively holding Mavis's funding.
Okay, so so the invoicing and the fees still work the same. There's
Correct.
no charge through to whoever that aged care
No.
or disability.
I would also add, just for your context, in the NDIS, it's not unusual for NDIS participants to use a plan manager.
I know, I've got someone in my family on it.
Yeah, or a support coordinator. So those people can also interact with the platform as appropriate and permitted under regulations. But it's still, the contract always exists with the client.
Right, okay. So what you're saying is those providers act a bit like support worker or support coordinators in that they assist whoever's in the home or in the care facility with accessing a care worker.
They're intermediaries for the client, so they're effectively acting as agent for the client to be able
in the same way that a support coordinator would be.
Absolutely, yes. Okay. But there's no difference at all in terms of Mable's pricing model because ultimately the costs are borne by the client.
I think at the core of your primary submission is that if in fact your model is such that if in fact payroll tax was imposed on your model of contracting, then it may make the business unviable. Is that correct?
Well, yes, it may, as a second or third order consequence. I think the primary consequence would be that in most cases people would be getting less hours of care, which would then make using the platform less attractive to them. So over time, does that make our business unviable? Yes. And to your earlier question, the keeping me up at night, suddenly get hit with an assessment, there's no ability to go and recover that from a contractor or go and recover that from a client. So that
if it's
definitely
retrospective,
that retrospective would definitely pose an existential risk.
So effectively the thrust of that argument then is not so much that the law might be wrong, but that we ought, as a matter of public policy, because of the service that you provide an exemption for the sort of platform that you operate.
Yeah, I would say our evidence here today is twofold. That by our reading of the Act, we don't believe we should be captured, and because the relationships on the platform do not at all resemble employment, but I also appreciate other people have other opinions, and so we would say as a public policy matter, it would be in the interest of this committee to recommend in favour of a broad-based exemption for independent contractors working in healthcare.
Do you accept, though, that some of the larger scale medical practices have similar sort of arrangements to what Mabel does, in that the invoicing is done by like the head administration, but each individual doctor runs their own practice with their own clients, and yet
I do, and I accept that there's a precedent whereby the New South Wales Parliament has granted an exemption.
they got a carve out if they got 80% bulk billing.
And for contrast, 90% of all
80.
supports on the Mabel platform are Commonwealth funded.
Yeah. Well, that gave rise, of course, to the intervention by the government as a matter of public policy, that they wanted to be able to keep those medical practices together.
And we would argue that it's in the interest of both workers and clients for a similar thing to be considered here. Keeping in mind that, one of the great things about Mabel, that one of the reasons I've chosen to work here as a member of the Labor Party, is because contractors are able to earn on average above award rates, which I think is admirable.
More from the government? Mr Nanva, anything from you? The opposition?
All good.
Concluded. Thank you very much to Mabel. We very much appreciate your submission, you taking the time today to give evidence. I don't think there are any questions taken on notice.
Oh, yeah, lots.
Yes,
were they?
there were two.
Couple?
Yes.
There were two.
Yeah.
Then apologies for that. We will be in contact through the Secretariat in due course to get some answers on those. There's an extended period for providing those answers because of the Christmas break. But once again, thank you very much for your submission and for coming here today to give your evidence. Thank you very much.
Thank you very much.
Thank you very much.
Thank you.
Thank you.
Hope we've got the names right. Okay, great. Thank you. Before we commence, if I could get you to state your name and position title, please, and swear either the oath or affirmation, and I'll start with you, Ms Sandler.
My name is Marissa Sandler. I'm the CEO and co-founder of Care Seekers, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. And you, Ms Hockley?
I'm Lauren Hockley. I'm the co-founder in charge of marketing and tech at Care Seekers, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. Do you have an introductory statement you'd like to make?
We do, thank
Please.
you. So firstly, thank you, Chair and members of the committee, for the opportunity to appear at this inquiry and hearing today. Care Seekers is an online platform connecting individuals and families with aged care and disability support workers. Around 70% of our activity relates to the NDIS and 30% aged care. We are a small business operating on very thin margins in a highly regulated area. Care Seekers operates using an independent contractor model. We chose this deliberately and sought legal advice to ensure it was structured as a genuine contractor arrangement. The workers on our platform operate under their own ABNs, set their own rates, choose which work to accept, and contract directly with the people they are supporting. We provide platform infrastructure, including insurance, invoicing and payment facilitation, and we do this for a small fee to ensure that workers retain the majority of what they earn and that public funding stretches as far as possible. We've always acted in good faith. We have an internal finance team, an external CFO, and our accounts are audited annually by a reputable mid-tier accounting firm, William Buck. At no point were we advised that payroll tax might apply to payments made by the independent contractors on our platform. Like many small businesses, we understood payroll tax to apply to wages, not these genuine contractor arrangements. In October 2023, we were notified by Revenue New South Wales that we would be audited. We were told a specialist team had been established to review care platforms and that a broader position on care platforms would be taken. The audit was paused for a period of time following the Supreme Court decision in Uber and later recommenced. In April 2025, we were advised that Care Seekers was liable for payroll tax on all contractor payments with a 5-year retrospective liability of more than $900,000 once penalties and interests were included. We are expected to pay this liability despite having lodged an objection, and as you're aware, the High Court has granted special leave to appeal last week in Uber. Even with a payment plan, the amounts we've been advised potentially may be required in each instalment would likely resolve in insolvency for a small business like us. We recognise the importance of funding public services and want to be part of a fair and sustainable solution. The issue for us is the retrospectivity in the context of an ambiguous law. The current payroll tax legislation in its application to platforms like ours is not clear. Many small compliant businesses, advised by lawyers and accountants, have not understood that payroll tax could apply to genuine contractor models. Retrospective application in these circumstances doesn't change behaviour. It simply destroys small businesses. We're asking for clarity, prospective reform and fairness, not an outcome that penalises small businesses that acted in good faith. Having been through the process, we also have a number of suggestions around the current exemptions that we would like to raise during our question time, particularly relevant to the NDIS and aged care sector. Thank you.
Thank you very much, Ms Sandler. Mr Tudorhope.
I noticed you sat through the whole of the evidence of Mabel Technologies. Is your platform much different than theirs?
No, it's very similar. The one point, maybe it's just a clarification point because I don't know exactly how Mabel operates, but in terms of that concept of the contractors writing a contract, which I think was Dr. Kane's question, ours works a little bit differently. So there's a blank templated document which, through a process of negotiation between the care recipient or their representative, it is usually a representative, and the worker, that template is filled in, and it covers areas. What are the rates that are going to be charged? What are the days, hours worked? Having said that, if there's a change to that, if they decide, oh no, I'm going to come on a Tuesday, it's okay. Like it's not a set in stone, abide by everything in this contract. But that's probably the only point that I would want to raise that is different. But it operates in the same way that the people come to the platform to search for workers who we've vetted. They connect. They use our platform to message initially. The payment is facilitated through the platform. Yes, very, very similar. One other point of difference, we are an NDIS registered provider. So sitting on top of us as a business is that level of compliance that we have to meet. And my understanding is that Mabel isn't. My most recent understanding is that they're not an NDIS provider.
They do put all their contractors through an NDIS screening check.
Yes.
You would have heard them say that in a way.
Yes, there's so much compliance in terms of being an NDIS registered provider.
If you had given evidence first and they were sitting behind you, you'd have to think that they'd be pretty nervous about what would happen in relation to them being audited, wouldn't you?
Yes, and they are aware that we have been audited.
And now have. So is it your... one of the things that they've put to us today is that there should be a specific exemption for the healthcare industry, whether it be aged care or NDIS providers and potentially the medical industry as well, or medical service providers as well. Is that your submission? I know notice you didn't make a written submission to the inquiry, but is that your position?
I think our position, we're in a different position in that we are facing a tax liability that we're unable to pay.
But in terms of a policy position, would you say that you should be an exempt provider?
I can see the benefits in us being exempt. We've gone through some of the hours where we do work out if a person, I can actually just name a few of the hours if you just give me a
How
moment.
many employees do you have, by the way?
We've got 8 employees.
Right.
So what we worked out is that somebody on a level 4 home care package who wanted to remain at home, if payroll tax, with the imposition of payroll tax, they would potentially lose, and the increase in the hourly rate, they would potentially lose 73 hours of care a year. A family supporting a child with a significant disability, so we just used an NDIS package of 100,000 would lose potentially 115 hours of support. So we absolutely can see the benefit in carving that out, especially given that it is all government funded and it's all the supports on our platform. Absolutely. Our first point, though, is real concern about the retrospective nature of the application.
I'll come to that. So that's the second arm of your potential argument is that as a matter of public policy, potentially should be exempted, but because at the moment you've now got a bill from Revenue New South Wales, and that covers previous years, and I think you did say that you obtained legal advice at some stage about whether you had exposure for payroll tax?
Can I talk to 2 points on that? The first is when we first set up Care Seekers, we really wanted to be a contractor model, and just explaining why. So my background is I've worked in human rights law, women's rights and disability, at Community Legal Centre for the last 5 years. And in that role, I saw very strongly how wonderful it would be if there was a platform in place that allowed families to choose their support workers. I was representing parents who had their child being taken away from them because of their disability. And it was a challenging part of that was putting in place a good support worker who could make an arrangement work, which was so challenging when you'd call an agency and they would send a different worker every single day. And I just thought if we could choose the worker ourselves, if the client could choose the worker themselves, this would be really different. Through all of those experiences, I also met many informal carers who were experiencing the financial difficulties that particularly women do when they are not in the workforce because they are caring for someone. They'll end up we know the fastest growing group of poverty is older women, and they're very anxious about going back to the workforce. And this idea, though, of being an independent contractor, okay, I can duck in and out. If I can't do that, if that doesn't work for me, I'm not obliged to. An employer really held an appeal to. There was a role for it, like what Mabel was saying. There's a role for all different types of businesses, and this was the business model we wanted to choose. So we got initial legal advice around making sure we were setting up a genuine contractor model. So that was the first piece of legal advice we obtained. Then we didn't obtain legal advice around payroll tax. It did not occur to us that it would apply to this genuine contractor arrangement. But in the last few years, as our staff has grown, William Buck has mentioned to us, you are fast approaching the payroll tax threshold, so be aware of that. But they were talking directly in relation to our 8 employees.
Mm-hmm.
Yep. So those are the 2 pieces of legal advice that we have received.
So the model of your business was never the subject of advice for the purpose of payroll tax?
No, never.
And consequently, the retrospectivity aspect of it probably came as a bit of a shock. As a matter of policy, of course, is that have you applied for a waiver of the penalties and interest?
So where we're up to is we've lodged our objection, and then we were asked, which apparently was quite unusual, even before they've decided our objection, for our view on penalties and interest. So
have you sought a waiver?
We're in the process of seeking a waiver, but it doesn't look like we necessarily meet. I mean, we'll obviously put in that we sought that William Buck did mention that, but the payroll tax, it's 2020 to 2023, the retrospective, and they didn't mention it in the documents in those years because we weren't as close to we were a much smaller team. So we are trying to put together a submission to get it waived. Of the close to 900,000, 800,000 is the principal, and then currently we've got about 40,000 in interest, and 50,000 in penalties, and that's not including, that's the right way around, and that's not including interest and penalties for 2024 or 2025, just because of the timing. They haven't come to us with that yet.
So would it be would you be asking for this committee to make a recommendation that where payroll tax is imposed as a result of a court determination which had not previously identified the organisation as being subject to payroll tax, then that there not be a retrospective application of that payroll tax?
Absolutely. To give a business like ours, we operate on very small margins, a moment to make changes that we need to our fee structure, to how we want to operate, understand this is the landscape we're operating in, and therefore these are the business decisions we're going to make, and then we know it, so that we're aware of the tax, the situation.
Yeah. Well, a lot of the evidence which you're now giving we've just heard from the previous witnesses, so it's a very similar model to Mabel, and I can understand the issues which you're making.
Thank you, and thank you for appearing. And I'm very sympathetic, Ms. Sander, to the reasons you were describing about the need for direct care and the flexibility it gives often women who are carers to undertake paid work. So I am sympathetic to that aspect of it. I guess there are a couple of questions, and it does echo a little bit what we've heard already, but one doesn't. I just wanted to be sure, because Mabel obviously is, because I think there's private equity involved there, but you're also a for-profit business, like it's a for-profit business, and you would engage, I'm presuming, sort of accountants and others too, and while understanding that there was audits undertaken and then paused while court cases went ahead, but prior to that case, there was also sort of a long history of cases of this tax being applied to businesses that had previously thought themselves to be exclusively contracting. So while we're kind of that sounds too harsh. While we're talking about the Uber case as if it was ground zero for payroll tax being applied to contractors, there has been a series of cases over a period of time. And so I'm just wondering how even an accountant might not have said to you, look, just wondering if you've considered the potential payroll tax implication. Like, I'm just wondering, because then necessarily it's not just you that, you've engaged with professional people who this is their area. So while you've said the legal advice didn't come through, anyone else who you sought business advice from?
When we went to William, but they're a very reputable mid-tier firm, they never advised us along those lines. It never occurred to us. And I appreciate what you're saying about those other cases. But for us, in a way, the Uber case was a bit of a ground zero, and it has being a platform. We've always been interested in how Uber does things. And when Uber was going on, we actually did sort of go, okay, well, let's make sure, based on what we know about Uber, how does our model, if this is being impacted by payroll tax, could this happen to us? And we actually felt that it couldn't, that we felt we are so different. I mean, the workers set their own rates. They choose who they work for. They directly negotiate. They do meet and greets. Like, it didn't at all feel, from a common sense and from what as things were evolving, we were looking at every Uber case as it was coming out and taking our set of circumstances and comparing it. So once we were aware.
But in saying that was you doing that internally. Yeah. You didn't seek legal advice. You were kind of trying to benchmark against what you were seeing coming out of the courts.
Yes.
Yeah. I mean, we're a small business, as you can imagine. Legal fees are, astronomical, and we do surround ourselves with, real professionals like accountants. So, they always kind of had our compliance in that respect. Mm-hmm. And we are also NDIS registered. So we are, always doing audits. And so as a small business, no one, we try and be across everything. But yeah, we relied on our accountants who would have told us this, because they told us about everything else, and they would always keep us, all the changes to superannuation and the way payroll is done through one touch, like everything like that came through. So we had we were never worried that we were getting, the wrong information in regards to our accounting.
Mm-hmm. Which in a sense further shows the ambiguity of what we were operating in, because they have pointed out other things to us. But
Right.
maybe it wasn't clear to them either that it
Right.
would have applied to us.
Okay. So there's a sense that you understood that there was potential there for what you do to be interpreted by Revenue New South Wales, at the very least, post Uber, as being liable.
And we were, yes, and we by doing our own internal checks, felt that this is where we're strongly different to it. Yes, platforms are new, and they are. It's this whole new way of doing business, running businesses. So yes.
Could you just explain a little bit? It came up initially. So you're an NDIS registered provider. So that differs from getting NDIS checks on your workers, doesn't it? Could you explain a little bit what that is?
Absolutely. So I think is it 20,000 NDIS providers? Oh, no, sorry. There's hundreds, I think 100,000 NDIS providers. I can take on notice and give you the exact numbers. And I think of that, maybe 16,000 are registered. To be a registered provider, you actually have to go through a formal audit process. It's done by external auditors who put the application into the NDIS Commission, and they will say yes or no to you being NDIS registered. You have to be audited every 3 years, and there's a midterm audit of every 18 months. The NDIS worker screening check is a new check that's been introduced across Australia. So previously it's all been done on police checks, and what they wanted to introduce was a check that would be 5 years in its length of time, that was transportable across all states and territories. So whereas here, if you moved from Victoria to New South Wales, you had to get a New South Wales worker screening check. And increasingly, the NDIS worker screening check is starting to replace. In NDIS, it's regarded as instead of a police check, and in aged care, there's a move to using one or the other. So they're actually quite different, the NDIS worker screening check and being NDIS registered.
Right. Okay. Thank you very much for that.
Mr. Nanva? Mr. Lawrence?
No questions from me, thanks, Chair.
Thank you. Thank you very much for your evidence today. We very much appreciate it, and we do hear your concerns loud and clear. I don't think were there any questions taken on notice?
There were a
One?
couple.
couple
Yeah,
taken
Ms.
on
Sandler
notice.
kindly offered. Yes.
The Secretariat will be in contact in due course to seek a response to anything taken on notice. But again, thank you very much for your submission. Thank you very much for the evidence you've given today. It is heard loud and clear. Thank you very much. You're free to go.
Thank
Thank you very much.
Thank you.
before we welcome our next witnesses, I note that in accordance with the standing rules and orders of the Legislative Council, with the prior agreement of the committee, Mr Ross Levin, partner, Mills Oakley, will be appearing as a witness in his capacity as lawyer assisting MSS Security today. Mr Levin will appear via video conference, and we have Mr Levin here. Do I have to swear Mr Levin as well? Okay, well, we'll swear everyone. So before we commence, I will need to get you to state your name and position title and swear either the oath or affirmation. And I'll start with you, Mr Delaney.
Yes, my name is Chris Delaney. I'm ASIAL's Workplace Relations Advisor. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr De Caires?
Yep, Brian De Caires, CEO of the Australian Security Industry Association Limited. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr Alcock?
Thank you. My name is Jeff Alcock, Managing Director of MSS Security. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr Levin?
My name is Ross Levin, partner of Mills Oakley. I solemnly, sincerely, truly declare and affirm that the evidence now to be given by me shall be the truth, the whole truth, nothing but the truth.
Thank you very much. Do any of you wish to make some introductory remarks before we commence with questioning?
Yes.
Okay, fire away, Mr De Caires.
Chair, Senators, thank you for the opportunity of addressing the committee today. I'd like to make 4 points briefly. Firstly, Revenue New South Wales' current interpretation of payroll tax provisions is not aligned with either the law or the reality of our industry, which works across every aspect of the economy. Security services support our clients, but they are not part of the client's core business. If you look at a supermarket, a university or a hospital, they do not operate in the business of security. Security companies supply a distinct professional, regulated and licensed service, separate from and external to the client operations. The security officers do not work in and for the client's business. Secondly, security personnel operate under a strict regulatory regime, the Security Industry Act, which requires a range of licensing requirements. Crucially, Section 38(1) prohibits licence holders from delegating security activities to unlicensed parties. This means clients cannot lawfully direct or control security guards in the way they would direct an employee. The security provider must, by law, retain operational authority at all times. This makes it impossible for security guards to be working in and for the business. The critical legal test for payroll tax employment agency provisions. Thirdly, Revenue New South Wales has recently applied its own, in our view, unreasonably broad and novel interpretation of the employment agency provisions in the Payroll Tax Act. This interpretation treats licensed security providers as employment agents, even though the courts have consistently recognised that ancillary services, such as those provided by security, do not meet the threshold of being a part of a client's business. Numerous case decisions, Nova, Security Group, E-Group, UNSW Global, made clear that the courts say that each case of whether a company is an employment agent is assessed on a fact-specific test, and the circumstances of licensed security services simply do not satisfy that test. And fourthly and lastly, we ask that you remove retrospectivity. Revenue New South Wales has issued assessments that retrospectively apply its new interpretation based erroneously on the trolley collectors case. This imposes millions of dollars in tax liabilities, penalties and interest on conduct that was confirmed by Revenue New South Wales as lawful and compliant at the time. This undermines the principle of legal certainty and places an unreasonable financial burden on security businesses. We also note that Section 40 of the Act currently deems non-labour costs, overheads, admin and even profit margins to be wages. We submit that this is inappropriate and inconsistent with the purpose of the payroll tax and should be reviewed or removed entirely. payroll tax should only be payable or levied on payroll. I'd now like to hand over to Mr. Levin, who's as a legal specialist, to provide a legal perspective on some of the issues, and then Mr. Alcock will say a few words.
I'll just say three things, members, and then Mr. Alcock's actually going to give you 6 specific suggestions and give them to you then also in writing as to what we think needs to be done to create some fairness in what I regard as an extraordinary overreach by Revenue New South Wales and the approach it's taking across the state. The 3 things I'm going to say, I'll just first say the way that Revenue New South Wales is misusing its power is it's taking an easy shortcut approach. You've got the courts when clients have the resources to challenge the assessment, and the courts apply a factorial test. Is the person integrated, kind of like an employee, into the business? Like a trolley guy, where the supermarket's saying, go and collect the trolleys, the supermarket manager's running them, controlling them, telling them what to do. They're integrated into the business and they're working in and for the supermarket. We get all that, but what's happened is, in real life, this has now been applied to everyone across the state. And there's no step being taken, and this is my point, by Revenue New South Wales to actually assess what is happening for a particular employer. So MSS is now facing 5 years of retrospective analysis based on some of its contracts that are then extrapolated to say, pay us $12 million. And there is no evidence to begin with other than contracts for some situations. Nothing is happening at Revenue New South Wales that applies the approach that the courts take to determining whether there's liability, because it's easy for them to do what they're doing. And that should not be the way an organisation with such power, where the onus then falls on the employer, the security provider, to disprove it. Second of 3 things, they have a policy which I find legally extraordinary. There is a section, and basically they say, let's just look at the total of the amount that you got invoiced by your subcontractor. So MSS has a subcontractor company providing some security people. They say, just pay payroll tax on the amount of the invoice. And their published approach is, in my opinion, legally and other even more experienced people than me, completely inconsistent with the plain words of Section 40, which, respectfully to Brian, they don't say that you assess it based on the total of the invoice. It says wages are to be assessed. Wages are to be assessed. And the plain words in Section 40, sub 1, sub A, should just assess payroll tax on the wages. Now, it's got some wider wording than that, but in short, across New South Wales, payroll tax, Revenue New South Wales is saying that just means everything. Anything associated with the provision of those subsidies, anything is included, and you have to pay payroll tax on that, which fundamentally, to all lawyers like me, you go, the fundamental purpose of payroll tax is pay it on the wages. Now, there's some slightly wider wording that's always been there, and now they're saying assess it on everything. Workers' compensations included, the profit margins included, leave entitlements, equipment, training, uniforms, things that have got nothing to do with what the payroll tax component is. That should stop. It's fundamentally wrong. They've used some cases that they say supports this approach, but it's really quite extraordinary, and we'll certainly be challenging it, but we say that this approach shouldn't be continued. The third and last point I want to make is that I know it's a lawyer thing, but when you look at what legislation is there for. You look back to why it was introduced. Second reading speeches, you would obviously be aware of them. When this was actually introduced in 1985, and the wording is almost exactly the same, it's just continued on, there was a purpose for this coming in, and it is not anywhere near the purpose now being applied by Revenue New South Wales. The purpose was to stop people who get a subcontractor and have just enough employees that those subbies don't reach the 3 million threshold where you pay payroll tax, and then you get another one, and then you get another one. So you are supplying a whole bunch of people providing a service for us. Security, cleaning, could be anything, but no one's ending up paying payroll tax. And so in 1985, when they saw that this was going on, they put in these provisions about, well, we'll deem you to be an employment agent. But what's now happened over the years, in conclusion, is that that is not the approach that's being taken to the interpretation. It's got nothing to do with that. And in fact, exactly what's happening with MSS is it engages subbies from companies who've already paid the payroll tax. They're paying it. And then we get told, well, you've got to pay because you're an employment agent. And we said, apart from the fact that they're not working in it for the supermarket or JB Hi-Fi, they're not integrated into that business, quite apart from that, it's already paid. But they don't dispute that. They just say, well, that's how the legislation works. Section 41 says you have to pay it because if you're the employment agent, you have to pay it. So it's a double dip. Thank you for listening, and pardon my passion about this, but really there's something quite wrong going on here, in my opinion, about the breadth of the power being exercised. Jeff?
Thank you. Mr. Alcock.
Thank you, and I absolutely concur with my colleague's view. I would like to give you 6 real-life, what I think are very reasonable and rational recommendations to make to this committee for its consideration. 1, suspend all Revenue New South Wales assessments that are based on the so-called employment agency assessments until this committee has had its chance to make its recommendations and those recommendations are acted upon. 2, the 2025 Nova security case appeal is heard, noting that appeal is being appealed by Revenue New South Wales, having lost the original argument. Those 2 things are real-life events right now, and we suggest that no assessments are undertaken, all suspended until those things are occurred. I would ask this committee, is it fair and reasonable that Revenue New South Wales plough ahead making multi-million-dollar assessments based on flawed interpretation of legislation while this committee sits, finds its recommendations, and there is an active appeal in place right now to that very act? 2, eliminate retrospectivity of all payroll tax assessments until at least the trolley case date, which was in late 2023. 3, eliminate what is blatant double dipping. As Ross explained, double dipping by Revenue New South Wales. My company pays payroll tax on its wages. My subcontractors pay payroll tax on their wages. The approach at Revenue New South Wales is effectively double dipping payroll tax for the same employee, for the very same employee. 4, ensure Revenue New South Wales employment agency-based payroll tax assessments look at the actual relationship between the client, my company and my subcontractor. In and for, as Ross said, not just the total invoice value, but take it out for what it is. Actually make the effort to make the assessment worthwhile and accurate. As I said, the looking purely at wages cost. Lastly, I've jumped to 5, but lastly, remove security industry from employment agency-based assessments. As Ross said, the original legislation was set up for a particular purpose. The security industry does not operate in that environment, does not operate in that methodology. So we would ask that those 6 things, and I would suggest to you that of those 6 very reasonable actions, and we'll provide this for you in written form for your interest, 5 of those apply well outside the security industry well. 5 of those are specific to every industry in New South Wales that's under this current regime, and the 6th one being the security industry in particular. We are coming to you on behalf of not just my company, but on behalf of the security industry and, for what it's worth, other industries that are caught up in this regime. and we would ask that you seriously consider those recommendations. We would also ask you, if the opportunity arises, to put those very questions to Revenue New South Wales, because I would dearly love to hear their response to that.
Thank you, Mr. Alcock. We'll now turn to questions from the opposition. Mr. Tudorhope.
I just want to get some clarity in relation to what is going on here. MSS provides, say, security for a sporting event at Sydney Stadium.
Yep.
The relationship between MSS and the security provided is an employment relationship?
Yes, it's generally a direct employee of ours. We employ something like 8,000 staff. We supplement our workforce with subcontractor staff depending on the service requirement.
So you're already paying payroll tax in relation to the 8,000 security people that you provide to for the purposes of the event.
Correct.
And in those circumstances, why is there a concern in relation to an assessment which you've received?
So there's the payroll tax that we pay our own staff.
Yeah.
Yes. The subcontractor that we may engage to provide supplementary services as well pays payroll tax on its wages.
So a subcontractor that you go out to and say, we don't have someone for this event, and you might, for example, engage another firm to provide, you're concerned about getting an assessment based on the subcontract that you've entered into for providing that service.
Correct, on two fronts.
Yeah.
And there's actually three fronts, but on two fronts. One, the assessment now, and Ross and Brian, please assist here if I get this slightly wrong. The assessment is based on the total invoice value from the subcontractor, only a portion of which is actual wages. So there's that point.
I know, I get that. I get that. But so...
May I add? So when you've got the sudden, and you've got, let's call it XY security, we engage them, they provide some other stuff at the event that you're at.
So these are not part of the 8,000?
No.
Now, these are additional people over and above the 8,000. So you've received an assessment for those, have you?
Yes.
Yes, so what we get
and what was the value of that assessment?
Ross?
12 million.
12 million. Have you appealed that assessment?
Yeah, we have objected, and we have said, so that's the first stage, sir, is you object to the assessment, and then that's considered. But in the meantime, you're still paying interest.
Interest is still running, yep. In relation
the thing
to...
is, what their argument is, sir, is they would say, well, those people, let's say it's at Optus Stadium, those people, your client, you are providing staff in the form of studies that are integrated into Optus Stadium's business. And we say absolute nonsense.
Correct.
They are not working in and for Optus Stadium. They work for us. They don't report to them. They don't get told what to do by Optus Stadium supervisors. They're security licensed people. They can only respond to directions that we give them. And the Revenue New South Wales people say, look, we've looked at the contracts. We're not looking at what actually goes on the ground. And that is their approach. Just look at the contracts. They say all of those extra staff, even though XY security company has already paid payroll tax for them, you should be paying payroll tax. And we go, hang on, payroll tax has already been paid. They go, it doesn't matter. Section 41 says you're the deemed employer, you've got to pay it.
Because they do answer to you at the end of the day. Isn't that the argument that they would run, is that they are subject to your direction and control?
No. What they're arguing, sir, is that those subbies are answering not to us, which would be fine. They're saying that these subbies are reporting to our client, to Optus Stadium. And it's like the trolley collectors, where the argument was sustained that the people in the red vests and green vests who are out collecting trolleys for Safeway were integrated into the actual store's business, following what the supermarket was telling them to do each day, and were integrated and working in and for Safeway or in and for Woolworths or Coles, not working for the security company. And you can understand why they would say that. Whereas security people working in the same scenario, the store manager there or the particular person running the study would have no idea if the person is a study or not a study, or an employee of MSS or not. So we are just being told, we're adding up all of your last 5 years. We say that when you engage, and this is all of them, sir, this is what's extraordinary. They just say 5 years, every invoice for all of the subbies, all of them, they say, were not reporting to MSS. These subbies were reporting to JB Hi-Fi, to Amazon, to all the places
with whom you did have a contract.
Security.
With whom you did have a contract.
Yes. If you have a contract, you're being assessed.
The submission that you made relies heavily on the findings of Justice Ward in E-Group Security versus the Chief Commissioner. You recall the submission that you have made?
Yes, that is absolutely correct. But they're even going beyond the trolley case.
Yeah, but it goes further than that. There is an appeal from that decision which you don't reference.
Yes, it came afterwards. So there are a couple of cases that after our written submission went in favour of the security company. One of which Nova, again, the tribunal said, well, these people were not working in and for the hotel where the security bouncers were.
Yeah.
They were reporting to the security company, not to the actual hotel. And they've appealed that. And because obviously they don't like the outcome, it's the same as the E-Group case, same as the Infinity case. And so what we're saying is, surely they should suspend assessments against security companies until the New South Wales Court of Appeal has heard that and decided it. They're pushing ahead regardless.
Okay. Mr. Levin, I understand the point which you are making, and in fact I think the submission is clear that it runs along a number of lines in relation to actually whether the employment situation is correctly interpreted. It runs in relation to the manner in which it's being assessed in terms of the interest and penalties which are incurred, and you're also arguing that assessing payroll tax in relation to an invoice is an incorrect measure of measuring payroll tax in terms of whether it's wages or not. I understand completely that argument.
Thank you.
Mr. Delaney, how many members do you have?
We have approximately 2,600 members, Senator. Not all of those are working in what we call protective services. Some, of course, are members who provide technical services like CCTV and so on. But on the protective services side, I couldn't be certain of the number of members, but there would certainly be 60, 70,000 employees in New South Wales.
So do most of your members, they would be paying payroll tax, I assume?
Oh, absolutely.
Yeah. Do you, as part of the requirement for membership of your organisation, take any steps to ensure that they do comply with their obligations to pay payroll tax?
I'd have to defer to Mr. Kerry.
We don't audit them for that. We did have a role of doing that up until about 2002, when there was a co-regulatory environment where we used to do that on a regular basis with face-to-face audits, but that was removed and the legislation was changed, so it was the co-regulatory model was shifted.
You do have the ability to exclude tax avoiders.
Where we have a range of different processes in place. If a member transgresses, whether it's a labour issue, whether it's a tax issue, that we can take certain measures to suspend or expel a member, and which we do that on not an everyday basis, but on multiple times a year, we will expel members.
Well, I want to ask you about the MASG group.
Mm-hmm.
They've been in the news recently, you're aware?
Aware, yep.
They're a member of yours?
Yes.
Have you taken any steps to have them excluded from your organisation?
We are bound by our constitution. We have taken a number of measures. We have a complaints and dispute resolution process which we have commenced.
You've commenced that?
Absolutely. We will go through a process.
They were a sponsor of yours last year, were they not, at your awards ceremony?
Yes, we seek sponsorship to help fund those events.
And you'd be aware that the reporting in relation to this group involved tax evasion?
There are allegations of that. We are, I suppose it needs to be stated, we're not the regulator. There are a number of regulators across different jurisdictions who are tasked with regulating the industry, whether it's tax office, labour hire authorities, security industry regulators. But we certainly have taken measures to instigate. We have a disciplinary committee which is investigating the matter as we speak.
Well, let me just, this is, as I understand some of the reporting in relation to this particular security company, it is alleged to have run a large unofficial workforce of thousands of migrant workers through front companies using corrupt payroll firms. Workers are allegedly underpaid and denied entitlements and set up, as said, to minimise or avoid tax. Front companies reportedly collapse when the ATO seeks recovery and directors then disappear or refuse to cooperate. Are you aware of that allegation?
Absolutely. But we have a constitution which we have to follow, which is the due process, and we are going through that process as we speak. So as far as I know, no regulator, state or territory regulator has taken action.
Well,
I think we've discussed this though with ASIL, and ASIL doesn't support breaches of any laws by any of its businesses, and there are rogues in all industries, and these people have had allegations. They appear to be rogues. We've got to give them due process about their membership. But what we hear about is the interpretation of the Payroll Tax Act. People like this are not going to affect how the Payroll Tax Act works. They are alleged to have had just an appalling series of breaches, but they are entitled to due process.
Well, thanks for that, Mr. Levin. I just think you're coming along here today asking this committee to, in fact, give consideration to the security industry as an industry which we should be giving special cognizance of in relation to their liability for payroll tax. So against that background, I just want to put some of this material to you to comment in respect of the way the security industry works in terms of its obligations relating to payment of payroll tax.
We in the proposals that are going to be given to you in writing, I can tell you that you will see at the end of it that in Mr. Alcock's proposal, it actually specifically says, however, it excludes anyone involved in tax avoidance. And so we are not seeking a blanket exclusion for everyone in the security industry, and we specifically have proposed that there be that exclusion so that they can be properly prosecuted.
And what's the test that you would apply?
I can read out the specific exemption that I've recommended for cases of fraud, any scheme of pyramid subcontract, or any anti-avoidance of any payroll tax.
And who monitors that? Does ASIL?
No,
does your organisation monitor that?
We don't have the authority.
We don't have a membership association like belonging to any club, any membership association belonging to AIG doesn't mean that they haven't got rogues. The point is, we condemn any cases of illegality, but specifically what we're saying is the security industry should be protected from assessments other than for cases of fraud where the Revenue New South Wales determines there's a case of fraud, or any scheme to pyramid subcontract, or any attempt to avoid payroll tax. So we've carved those out because we share your view about no one should be excluded from assessment where they are doing the wrong thing.
Thank you, Mr. Levine. I'll just go to Dr. Kane because
just very quickly, just jumping in from Mr. Tudhope's question.
I'm a bit confused because how would you prospectively include those companies that you thought might be engaged in those practices? I don't understand. So if you were seeking to exclude companies that were engaged in that kind of illegal or poor practice,
No, I think they're asking for an exclusion generally for their industry as part of the legislation.
Yes, but then as I understood it, you were then arguing that that exclusion wouldn't apply to bad actors. But how would you know in advance who the bad actors were so that they wouldn't get the benefit of that exclusion?
So don't give them the exclusion.
So, the way it works is exactly how it works now for the Income Tax Assessment Act, for your tax, for anyone's tax, for any liability in the employment world, is that when it comes to the attention of a regulator that something has been done wrong, they don't get excluded. Right now, the assessments being done by Payroll Tax New South Wales are being done on the basis of where they say payroll tax ought to be paid. And so in this case, if they come across a rogue actor, they say, just like they do now, you are not part of the overall exclusion because we have determined, and that is the power. Right now, they've got the power to include everybody. What I'm saying is give them the power where they determine, just like the anti-avoidance provisions are for your income tax, for all of our income tax. If you're involved in what the Revenue New South Wales says is fraud, not paying payroll tax by a scheme, pyramid, payroll tax avoidance, that's exactly how it works. It's always prospective, is that you don't have a liability until you're assessed. And the cheats get caught by the regulator. But right now they're going too far.
Well, let me just ask you about getting caught by the regulator. MASG used student visa holders in ways that allegedly breach their visa work limits and potentially migration law. Internal rosters and visa records show student visa guards on sites such as Coles, Amazon and Geelong Grammar working up to 7 days a week despite visa rules allowing only 48 hours a fortnight. One insider described a deliberate system where subcontractors funnel cash payments and rotate payroll companies annually to hide GST and tax fraud and to exploit workers in breach of visa conditions. How does the security industry monitor that?
Who's your question to, Mr. Chair?
Can I jump in here?
Senator,
we do not have the power that regulators have. You've got labour hire licensing in Victoria who have done nothing. You have LRD in Victoria who provide licences to security companies. They have done nothing. You have wage theft authority in Victoria who has done nothing, and you've got the Fair Work Ombudsman who've also done nothing. All of those groups have far more power than an industry association can wield. We are following a proper process based on our constitution to deal with allegations against a particular organisation, and horrible allegations as they are, and we must follow our constitution in that way. It is not our role to be the regulator, Senator.
Yeah, well,
there are plenty of regulators that can do that.
I just ask you this though, do you acknowledge that the issues which have been raised in relation to this company and which has been exposed raise serious questions about the governance and risk management in the sector generally?
No.
You don't?
I acknowledge that they create serious concerns about a particular organisation, but not the industry as a whole.
And you say that this doesn't exist anywhere else in the security industry?
Oh, of course it does. And I would.
Do you want to comment on that, Mr. Alcock?
I would suggest to you, Senator, that it probably exists somewhere in this building.
Mr. Alcock, do you want to?
Yes, I would agree with that. I think, and I know what Chris is saying there. The allegations that are put in that I've read in those articles are damning and very, very worrying for the industry as a reputational thing. I support what Chris says in terms of the industry generally speaking, and I talk about the larger players that I'm aware of that I compete with on a regular basis. That's not an issue, but there are rogue operators and there will always be rogue operators. I would hate to think we all get tarred with the same brush. We are getting tarred with the same brush by Revenue New South Wales right now.
I'm just mindful of time. Dr. Kane.
Thank you. Thank you. And I do want to just jump back. And it was an important line of questioning, but I do just want to jump back just to get a better understanding of, I think it was you, Mr. Alcock, was talking about double dipping.
Yes.
And one of the reasons I want to ask the question is because my understanding at the moment is a bit different in that I thought that Revenue New South Wales had determined that they will sort of sit the liability in the point in the chain that is closest to the end user, and that they didn't, when there's that chain of hire, that they didn't then go down and sort of have that liability down the chain. So I just wanted to check, because given the example you gave, it sounded like you and your contracted business both, you're suggesting you both paid payroll tax on the same employees for the same contract.
I'll let Ross answer that if you don't mind. And
No,
then
that's
I
okay.
might,
I'm just
I
trying
might
to be
come back
clear because that's not my
Yep.
understanding.
Yep.
That is exactly correct. The way it works under the legislation is that it sits with the way you described it. The person closest to the client pays. But what happens, what occurs in reality? Cleaning, security across the state is that because you don't get an assessment till later, the employer is employing its subbies. They pay their payroll tax. They assume, as the employer, that they have to, which they do. But what happens, and this is why it's so extraordinary, is, and why there needs to be a legislative change here, is that they say to MSS, but the legislation says you have to pay because you're at the top of the chain. And so you're right, and that is exactly the problem, is that we say out of the $9 million that we've been assessed, most of that is for invoices where almost all of it, the employees or employees, the person on the ground has already had payroll tax paid by their employer that we engaged. And Revenue New South Wales says, yeah, but that's just how the legislation works, bad luck. We're here to assess you. And what we say as a policy thing is surely they should say, well, we've got a discretion here. We don't have to prosecute you and assess you. And if we can see that we've already had all these employee payroll tax paid already, well, we won't assess you. But they do anyway. And that is exasperation that all of industries in New South Wales are currently facing. And Revenue New South Wales just points to the legislation and says that the top person pays, the one closest to the client pays. We say, you don't dispute that you've already had payroll tax paid. And they go, no, we don't dispute that. But that's not up to us. If you want to try to get that back from them, you can. Well, of course you're not going to be able to get it back.
Well, just in relation to that, though, that when you make the allegation that they are double dipping, they are in fact getting the benefit of a tax-free threshold, though, aren't they? The subcontractor.
But
the payroll
everyone
tax
has it once.
So
everyone has it once, sir. Yeah. So everyone gets.
Well, no, but you get the MSS will get its tax-free, its threshold, but the subcontractor who you say has already paid the payroll tax has got the benefit of a tax-free threshold. So effectively, for the argument that you're making is that they've already paid the payroll tax. Well, they haven't paid it at the same rate because they've got the benefit of a tax-free threshold, have they not? The subcontractor?
I think that if you're talking about it at the very tiniest margin, yes. The amounts we're talking about here, sir, that threshold, 3 million at 4%, that's not what's going on here across the state. What's going on here across the state is we are engaging other employers with thousands of staff, hundreds of staff, way above the threshold. The threshold's not the issue here, sir. It's double dipping. They're getting payroll tax on both. There is a tiny point, a tiny piece at the bottom of threshold.
Just one question from me. If I
Of course, Mr. Lawrence.
for you, Mr. De Caires. Just in relation to this MASG group, are you investigating them in your internal processes in relation to anything that's occurring as a result of their contracts in Nauru?
No, we have no jurisdiction beyond the Australia.
Yeah, because it just occurred to me as you spoke, one of your colleagues spoke, that all the regulatory bodies that exist in Australia, which you were talking about, don't exist in Nauru, correct?
Yep.
And there's a company that is primarily from Australia that's operating in Nauru, and if they're misconducting themselves here, they're probably doing it there as well, perhaps. I'm sure you'd agree.
If it's the same, it's a different. I think they have a different structure in place there, but we don't cover that territory.
Yeah.
But certainly going back to one of the things that we've been pushing for close to 30 years is to have nationally consistent licensing requirements, which would address the issues of getting rid of the access to a license, which in New South Wales you can't be a student visa holder, backpacker. You have to be a permanent resident or a citizen. We have been pushing for that for 20 to 30 years.
But in terms of your internal processes and the way that you handle complaints, do you think that there might be cause to expand it to look at what Australian security companies do overseas? Because you might assume, for example, that regulatory bodies in Nauru might not be able to properly look at matters.
I think that would be possible, but as our constitution is based on Australia, not New Zealand, not Asia. We have a number of global companies that are members. We just do not have the remit to do overseas. We're not a huge corporation. We have, 12 staff. And we've got an industry where we have about 2,700 members, employ about 150,000 people. We are trying to hold all of those to account.
It'd be wonderful.
So couldn't you make it a condition of membership, though,
that
a company not misconduct itself outside
we have a
of Australia?
code. We have a professional code of conduct, but we have to go through a due process, and our constitution dictates what we have to do. And we do have, as I said, a disciplinary committee, which is chaired by an independent legal expert, and we go through a process. And we do expel members every year, but we go through a process. It's not a kangaroo court. It is a due and fair process.
Sure, membership fees from this company still?
Every member has to pay membership fees.
So you're still accepting their fees?
Well, they are still a member.
Yeah.
Dr. Kay?
Could I ask what percentage of the industry are members of yours?
We would have, across Australia, there's about 13,000 security companies with a security license of some form. New South Wales has about 6,000 of those. We have about, as Chris said, about 2,500 organisations that are members. But in terms of value, that would be about 80% of the industry by market value, not by number of companies.
And the subbies, are they members, or is it just your lead firm? So
No,
does it go down the chain?
We have the majority of our members are SMEs. So the nature of the industry, it's an on-demand service. So if there's a Lady Gaga concert last week, they would need 300-400 guards for 2 or 3 nights. Then they would not be needed for 3 or 4 nights. Then something else comes up. So it is an on-demand service. So occasionally companies will need to subcontract to supplement their workforce.
So what I'm trying to get at is, say for example, the MSAG, if they were excluded from your organisation, what would that mean anything for them in terms of their capacity to contract or business?
Absolutely. In some jurisdictions, not this one, but certainly in Queensland and in the ACT, membership of an association is a condition of having a licence.
Right.
So their revocation or suspension of their licence would make them unable to operate in that particular jurisdiction. But it was the case in New South Wales, but that was removed in 2002 when the co-regulatory approach was dismissed.
Thank you, Mr. De Caires. Well, that ends the time for questions. We very much appreciate you appearing today to give evidence on behalf of your association and your companies, and for the submission that we have received from you. Were there questions taken on notice? I don't think there are any questions taken on notice. No. So thank you very much for your attendance and your appearance today. Much appreciated. Thank you.
Thank you all.
Thank you for your time.
Thank you. Thank you. Before we commence with the hearing, if I could just get you to state your name and position title and swear either the oath or affirmation, please.
Yep, thank you. So, Peter White, I'm the Managing Director of the Finance Brokers Association of Australasia, and I'll take the affirmation whereby I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. White. Do you have some introductory remarks, an opening statement that you would like to make?
Yes, I do.
Please.
And through the chair, if you see me go for my ear or my phone is connected to my hearing aid, so I may need to make an audio adjustment, but it's nothing more than that. My phone is on silent.
Thank you.
So by way of opening statement, I guess I'd like to read from this that the association was surprised to hear the initial ruling that has been brought down by the courts of recent. In particular, that would be in relation to the loan market group, which is one that's now basically concluded, I guess. The characterisation of a broker providing services to an aggregator as a contractor runs completely counter to how the arrangements work and why they were created in the first place. To be clear, the relationship between an aggregator and broker is not structured to avoid tax or obviate obligations of either party. The arrangement is not a sham to circumvent employment laws. Aggregators provide services to brokers. Aggregators exist to help self-employed brokers, of which there's currently around and just over 22,000, have access to a wider range of panel of lenders so that brokers can provide services to their clients. Brokers find the client and have a direct relationship with each one. Aggregators have no relationship with the individual clients of the brokers. They merely provide mechanisms for which brokers can lodge applications to a wider range of lenders solely for the benefit of the client. After the mortgage broker best interest duty was legislated, the ability to lodge applications with a wider range of lenders became even more crucial. Mortgage brokers must hold accreditations with multiple lenders to be able to comply with the best interest duty obligations under the NCCP Act. Without an aggregator, every broker would need to be accredited with every lender for who they want to be able to recommend loans. Historically, lenders required individual brokers to pay to become accredited and thereafter submit a minimum number of loans every month or quarter or year to maintain that accreditation. If a broker did not lodge enough applications, they would lose their accreditation and have to pay to become re-accredited. Naturally, an individual broker trying to hold accreditations with many lenders would be under tremendous pressure to place enough applications with each lender to keep their accreditations. Aggregators help brokers comply with this very important obligation by maintaining the accreditation with each lender and then permitting brokers to lodge loan applications on behalf of the broker's customers. Thank you.
Thank you, Mr. White. Some questions from the opposition, perhaps.
Thank you.
Mr. Rath.
So in terms of these aggregators, so you argue that the brokers are essentially customers of aggregators.
Yeah.
Is that right? Could you explain that relationship a little bit more, how that works?
Well,
why revenue's got a different interpretation of that?
Yeah, that piece I don't know if I can answer.
Yeah.
But
do you want to take it on notice?
Yeah. Well, yes, I can't really determine why Revenue New South Wales are making their determinants.
You're taking the part about Revenue New South Wales on notice, not the part of the mortgage brokers. Yeah.
So the relationship or the interactions, if you like, with the aggregator and the brokers are actually submitting loans on behalf of their clients. It's not on behalf of the aggregator's client. So it's not Peter White Home Loans, Finshaw Group Home Loans. It's Peter White Proprietary Limited Home Loans. The aggregator doesn't come into it. It's not a party to it. It's a mechanism to be able to supply the loans or supply loans into specific lenders. It's not the other way around. The aggregators are not providing, or the brokers are not providing the service to the aggregator.
And how long have mortgage brokers used aggregators for? How many years?
Interesting. So I'm into my 47th year in this industry, in banking and finance in Australia. I was involved in some of the early businesses that got involved in aggregation, and so in its very early stages it was around the late 1980s,
right.
But more so as we stepped into the early 90s.
So late 80s, early 90s, mortgage brokers start to use aggregators. But from that point until, I assume, the loan market case, the assumption, the working assumption from the industry is that you were not liable for payroll tax in that instance. That was the assumption that mortgage brokers had.
I think it was more than assumption. The industry, and we were not involved in this, so I'm speaking from knowledge rather than being in the middle of it. Industry engaged the likes of PwC to make sure they're meeting their obligations in an appropriate manner and making sure that they are paying their taxes, whatever that may be. And their guidance, from my understanding, was that you are meeting your obligations, you're not liable for payroll tax.
That was the auditor's,
viewpoint. Yeah.
Right. So up until the loan market case, you didn't have any reason to believe that you might become liable for payroll tax in the future.
No, I don't believe so. I know I established Rams Home Loans first offices back in 1993, and I know there was discussions, although I wasn't directly involved in them, around were contractors employees or were they contractors? And it was deemed by the mechanism that company went through at the time that they were truly contractors and not employees. So that was a long time before that, or a time before that. Yeah.
And has Revenue New South Wales given any advice to your members about what has made them, what's been the impetus for this change? Or have they just essentially said, here's your bill?
As far as I'm aware, they've simply said, here's the bill. And that's why industry is very concerned about it. And it's not just here's the bill. We are looking retrospectively in loan market back to 2012.
Yeah.
So it's a significant bill. And so saying, well, wait a sec, as far as we're concerned from an industry point of view, from a business point of view, we are compliant to our obligations, because none of them are out to avoid paying their tax, and they pay their tax handsomely, as much as they want to complain about it. But that's the way life is. Yeah, it's been that way since that period of time, and it was a shock for when this started to come down, from my opinion, anyhow, from my view. And remember, as an industry association, I'm not in the middle of this, so I'm looking at it from my perspective.
Just a bit of history, Mr. White. So where did you said that aggregators emerged in the 1980s? Late 1980s. But at sort of whose behest? Was it the lenders or the brokers?
No, it was the lenders.
So it was actually from the lenders' point of view.
What happened around that time was the broking market was starting to grow, and we had the banks trying to shut various things down, but at the same token they found that they needed to work with them. The problem they were becoming was, as things started to scale, it was a lot for the actual institution to handle. So they then encouraged this idea of an umbrella group, an aggregator, to funnel things through to give them greater capabilities to manage the volumes that got to their end. So it was largely technology, education and training based, and then the lender would push down the commissions back through their portals, and then they were distributed out.
And you wrote to the Premier's Department in April 2024, which is a large part of your submission. Did you receive a response?
No.
No reply.
No response. No.
Or have you written to anyone else, Revenue or
no? We haven't.
Treasurer, Premier.
Premier, yes.
Yeah.
But we hadn't. There was certain things that once this went to court, the people who were at court said, "Hey, step aside for a bit. We've got King's Counsels, Queen's Counsels, whatever involved. They're arguing the case. Let them run it." So we stepped back a bit, but we put our positioning paper back then, which I have copies here if others don't have a copy of it, together with some research data if it's of interest. But yeah, so we hadn't made any further submissions. I had spoken with the Premier at a small function, I think it was about 6 weeks ago, and then I received the invite to be here.
Right. And so you represent 13,000 finance and mortgage brokers. What sort of proportion of is it an industry or a profession?
It's an industry, I guess. Yeah.
What proportion of the industry is?
So as of this morning, my memberships team advised me we just crossed the threshold of 13,800 members. The industry itself, based on some research I have here for if you want it, there is, as of September this year, over 22,002 individual brokers in Australia. When we look at our membership numbers, we look at it from a natural person's point. So many brokers have companies. We don't count that in our membership number. It's purely natural person piece.
So basically the Revenue New South Wales wasn't correctly enforcing the law for 30 years.
Well,
and they've only just started to enforce it based and retrospectively, or they've changed their view, they've changed their interpretation.
Correct. And look, you know, and this is a part of the challenge for industry. Says, well, if we're out of lockstep, and regardless of the advice we got, if the actual law stated something and we weren't compliant to it, why wasn't this addressed many years ago, back to 2012, when this is where the fee collection revenue is they're chasing or have been paid? Why is it now? Why wasn't it all that part in time? And of course, everybody gets a little bit nosy about it and so trying to pay for the pandemic and all this sort of stuff. But the reality is, if there was a problem, it should have been dealt with ages ago. If there's a change in law or in legislation, we're all big enough to understand that this happens. But the appropriate and fair thing is to say, we're drawing a line in the sand. You may not like this, and the industry probably won't, but they'll get over it. There's a line in the sand. From now on, it looks like this, and you're going to pay payroll tax. And you've got 12 months, 2 years to adjust, whatever that time frame is. Because there's with 22,000 people in the industry, there's a lot of things that need to be worked through to make sure everyone's compliant, because everybody wants to comply.
What would be the, it might be difficult except by way of example, but what's the sort of scale of the retrospective payroll tax bill that a mortgage broker might need to pay? Like,
well,
what are some...
I don't think I can actually answer that, because...
But it's considerable,
the bill to the aggregators, because this is a tax on aggregators, it's not on the broker, but what happens is the aggregator passes it down line.
Yeah.
So it affects these 22,000 people. They're all small businesses just trying to make a living. And a lot of them, not just are small businesses, a lot of them are micro businesses. They're mum and dad businesses operating at home. So all of a sudden there's enough complaints about the Ombudsman's fees increasing or the levies are increasing and so on. This just adds to the quantum of that measure, makes it more difficult for these people. Because misreputations in the media, these brokers don't earn millions of dollars. Most of them on an average wage of about $85,000.
If you could provide on notice maybe an example or two of a mum and dad mortgage broker company, they employ, this might have a couple of people, but they've been hit with a whatever it might be. You don't need to disclose actual.
The only challenge is things are still not out of court, so the indeterminations are still.
If you can.
Yeah.
If you can.
I should be able to get a quantum measure for you on notice.
Thank you.
Come back to you.
So can I just get the understanding, the Rams home loan example that you used?
Yeah.
Rams was like the aggregator, is that correct?
Yeah, Rams was more. It was very unique of its time. It was the actual first true non-bank lender. So they were securitising and raising bonds out of the capital markets, but they had more of a franchise network together with a broker distribution network as well. So with the broker distribution network, it acted more like an aggregator because it wasn't enforcing just its own product.
So who was getting the land tax? Who was getting the payroll tax bill?
There was none at that stage.
Well, but if they were today,
well, it should have gone to Rams.
Rams, and effectively Rams would pay a payroll tax on the basis of all the brokers who it engaged for the purposes of providing.
Subject to that determination of what fell within the agreements.
And it would then pay the fee to the broker. So it isn't the individual broker who's getting the payroll tax bill, it'd be the aggregator.
Correct. It's a tax on aggregation, it's not a tax on the individual broker.
Yeah,
but
correct.
It does get pushed down.
So there's since 2024 and the loan market case was decided, have you got any figures on how many of your members have in fact received payroll tax assessments?
No, I don't.
Or
I could investigate that for you. I don't have that number.
And there is another case which is currently on appeal called Finshaw.
Correct.
Are you aware of when that case might be decided?
The information I've been given is it's probably going to take till September next year before it concludes.
Okay.
So, but I think one of the things that's important, and I don't know if Revenue New South Wales have got their head across this, is not everybody's under the same agreement. So one of the challenges for loan market was within the diversification and structure of their business, there were multiple entities. and some most certainly were liable for the payroll tax. And I think that was in their franchise areas. That's a very different model to what is the vast majority of brokers in Australia. And the problem is, I think it's the same brush that's been tarred of for everybody.
In fact, because my understanding of the way broking industry works is you go to a broker who will potentially access loans from multiple organisations rather than just...
Unless it's a franchise, they may have different arrangements, but I'm not up to speed on the franchise models.
Yeah, well, the franchise model is a different model, but the aggregator model would be, if it is funneling it through one source only, then potentially there is an argument subject to the control of that.
This was expanded through the best interest duty legislation when it was enacted. So it was, and we argued at a federal level, because obviously brokers are governed by the NCCP, which is a federal act that ASIC sits as regulator across. But it gave the ability for brokers to be able to give and be governed by law to give more options than just the one or the two. Although there are some cases where there is only an option of one or maybe two that we gave to the legislators back to Treasury at the time. But it does give that broader depth of opportunity. The challenge from my point of view, and the beauty of the best interest duty, is that there's not a requirement on the broker to deliver volume, right? Unless they're just not operating. So if they haven't written a loan for 6 to 12 months, they'll lose their accreditation. And that's not volume-based, it's risk-based. And the risk is they're not up to speed with the current requirements and credit policies of the lender, so they shouldn't be basically using their product. But it removed that conflict of interest of being driven by a volume necessity to be able to maintain your accreditation, which was not a good thing of the day when those things were happening. And very pleased we're past that.
So the submission you make to the committee is that there should be an exemption for brokers?
Yep.
How do you see that as operating?
Needs to change the law.
Yeah, but what's the change that you would... how would you draft the change for specifically for your industry?
Yep. I would have to speak to my colleague who's back in the office to how we would actually draft that. Happy to take that on notice. I am not a regulatory writer. I am the person who sits here to make comments.
Okay, well, the second representation you make is that to the extent that there is retrospectivity involved in relation to assessments, that should be
excluded,
not pursued in terms of giving people an opportunity in new industries to potentially get their affairs in order for the purposes of paying the payroll tax.
As I mentioned before, draw a line in the sand. But I can actually draft it for you. My colleague is ex-ASIC, and he's written many regulatory policies for them in the past.
In terms of the industry, just to be clear, because we've had submissions, I think, from another organisation that represents mortgage and finance brokers.
Yeah, the MFAA, I'd imagine.
Okay, and I just wanted to understand if there was a difference or, submissions, what you seem to be saying seems to be pretty much the same, but I just wondered what the breakup was or what the difference.
So I can only give to you from my understanding is that we probably have landed close to the same place. I think some of the logistics and logic that we apply to the reasons why are possibly different. And that, I guess, is because the two associations come from a different place, if I can put it that way. Okay. We're known to represent the individual broker at the coalface, and we don't take sponsorship from major banks. The other side have lots of money that comes from the banks, and that may sometimes change perspectives on things.
Okay, no, that's kind of what I wanted to understand.
Well, that's where
the difference in your associations.
Yeah, and that's why people choose one. And it's, I've worked hard over many, many years. So I've been with the association since 2003 in some shape, form or another. That people need to have choice. And especially when you're talking about small business people, if you're in business for yourself, you want to make the choices of your own decision. You don't want to be dictated to by somebody saying you must do this, you must do that. So I'm all about choice. And this gives choice. We have, I guess, those different underlying ethos as to how we go about things, how we approach things, but we're still, united and I guess on the best interest of the industry to make sure that it's professional. We went back through when we changed from the UCCC into the NCCP because there were rogues back then in the industry, back in that prior to 2000 or through that late 90s into the mid-2000 era that led into the Act coming in 2009 for the NCCP. To get rid of the holes in the fence, because people who want to do bad would just say, well, that's okay, that's now too hard, so I'll go this way because it's easier. So we don't want those people in the industry, and we're all united on that.
Okay. And in terms of sort of size or market share, in terms of your memberships with the MFAA, do you have any information about?
Yeah, so I have information here in regards to market size, which I've made enough copies for everybody, should you want them. In regards to market share, I can give you, and I'd have to send it through separately, a recent piece of research we've had independently done by a global research house called Core Data. They do a lot of our stuff, whereby the media will tout, and maybe the MFAA will tout, that brokers are around 78% market share. Unfortunately, their research is not all-encompassing of all loans that have done, and they've missed, don't hold me to the exact number, but I think it's around $27.5 billion worth of transaction in the banking system that brokers don't get to see. They could be internal changes and so on, but with the presence of brokers, they should have the opportunity of it. And it falls more in line with APRA's recent data that says it's around 62% market share. And there's nothing good or bad about that. It is just what it is. I think when media gets hold of these numbers and it says 78% market share, regulator gets all a bit concerned, the risk level's gone through the roof and so on. Well, we've had, we look at, say, the Ombudsman started through AFCA. I think the current rate of total cases against mortgage brokers to the total case numbers they see is around 0.3%. We know the ASIC did an audit into the best interest duty about 1.5 years, 2 years ago and stopped because they couldn't find anything. I even asked for the data that they'd collated to that point. So, yeah, we haven't even done that. They've reinstated that again. So that's already underway from earlier this year, an audit back of broker loan files under the best interest duty. So far, touch wood, there's nothing come ripping out of the market saying we have a serious problem here. I dare say our regulator, being the policeman and watchdog that they are, will go to find something. I don't believe there'll be anything systemic, but there's probably things we need to tidy up. No one's perfect. So we thoroughly expect that that will be the outcome, or something like that. So the industry is actually very professional and one of the most highly regulated in the world. I actually sit and I founded what's called the IMBF, the International Mortgage Brokers Federation. I established that in 2016 between myself and Canada, and it's a collaboration of 6 countries and hopefully 8 by the end of 2026, working to look at best practice and challenges and issues in mortgage broking through third-party distribution around the world. And we have the highest standards. And I say that every day because they also say we don't want to come and work there. They liked how we survived the pandemic. That was a good point. But they didn't like the regulatory frameworks we got. From our point of view, love it, bring it on. The more the better. Every time we've changed legislation, we have increased and improved our industry.
Thank you.
Thank you, Mr. White. No more from the government, opposition. Thank you, Mr. White. There were a couple of matters there I think you took on notice,
yes,
some documents that you'd endeavour to get to us.
There were, I think, 3 or so.
They'll come through in the Hansard, will it?
Yeah, they will. The Secretariat will follow those up with you.
Thank you.
Thank you very much. We'll make sure they reach out and get those from you. But thank you very much for your...
I have some other information here if you want it that I spoke about now, but I've got them in hard copy should you want them.
Yeah, sure.
Well, if they're hard copy, you can...
Yep.
Yeah, you can hand them around now. Well, thank you very much, Mr. White. We appreciate your attendance today and the evidence that you have given the inquiry. Much appreciated. Thank you.
Thank you.